1072 of 22.
Appeal is allowed, no order is to cost. In view of the judgment on order delivered in Rate Appeal 239 of 2021, interlocutory application stands dismissed.
Kindly done this with us. I am seeking leave of the court to allow me to move an unlisted criminal petition. Well, yesterday it was supposed mention was made for today. Unfortunately,
What is the issue?
look, the cognizance by the lower court has taken on a repeal provisions.
When is the next date?
Next date, it is on 30.
13th.
Yeah. Well, kindly accommodate me as the last item, Lord.
Last item.
The last item, Lord. I am here because travel all the way from Icharega, Lord.
No, right.
Grateful, Lord.
Traveling from Itanagar is quite pleasant, I believe. Now there's a flight.
It's always better, Lord.
All right.
Yes, sir. Item number 49, Malada. There is a charge sheet case, some water citizens passed by the trial to file. So that those things actually got them, they got by an affidavit, my lord. I have taken consent from the PP man.
There's a request to
Possible for the thing.
Mr. P.K. Roy Sovereign. Matter stands adjourned. Let it come upon reopening because you'll have to bring it on record.
But I will finally do this thing. Only possible for it. Yeah, only possible.
The Passover for the day doesn't make sense in the vacation bench.
Malad, I will try to, because 6 is not possible, Malad. I will try to bring it to record affidavit. I've got the
That an additional affidavit required to be filed to bring certain documents on record. Matter passed over for the day, adjourned for the day.
May I please proceed? I declaration item number 67 of the today's list. The matter may be passed over for the day. Because the Armenian council is out of station.
Your name?
IH Lashmi.
Mr. I.H. Rosner, learned counsel to the petitioner. Subjects, the matter be taken up after reopening. List, case diary received. List this matter again on 18 July. CD received.
20. It is put in your 20.
20. All right, 20. CD receivability.
I will register. I'm trying to for listing the BPC matter, eviction matter. Already eviction notice has been issued.
Today,
Yes.
subject to time being permitted.
Yes.
Subject to there will no defects. You'll have to bring it before rising of the court.
Already.
Wait, please. I mention item number 56.
Yes.
Probably the CD
56.
56, yes.
Probably the CD is not available. Can the matter be so
56 cities not available.
56 CD not available is on 20 July.
Can it be on 11, 7, 6?
No. 20 July.
May I please, your lordship? Lordship, with instruction of my client, I declaration item number 69 of today's list. I may be allowed to withdraw the application.
69.
69 of today's list.
Mr. U. Chaudhary, London Council, appearing as a petitioner on instruction submits that the petitioner does not wish to press the bail anticipatory.
Anticipatory.
The same is accordingly dismissed as not pressed.
Obligation.
Interim order if any needs as vacated.
There is no interest. Obligation.
Lordship, I beg to mention item number 59, Lordship. CD not available, Lordship.
59,
Lordship. CD not available.
CD not available.
Lordship, 110 days behind the guard.
List on 20 or 18, we can have it on 18.
Lordship.
List on 18, CD we go for.
Yeah. On item number 73, came many times over, my lord. Didn't reach. Can it be a true, my lord, we follow this type of some accommodation?
We cannot guarantee you the time.
No,
We take it up before the court rises.
My lord, highly available.
72,
73.
70. All right.
Highly available. Highly available.
Item number 58. I have 65.
58.
These are the
No, it will have to be after vacation.
43 days, that will be
When did you get the CD? 58,
19th of July.
19 July.
6 days is whether it will be a
When is 60 days expiry?
17th.
17th. Let it be on 18th? 18th. 18th July. Call for CD.
18th.
Yes, please.
For motion BA, item 1 and 2.
Make video.
Yes.
Fourth and application manner. Here manner, the petitioner has been shown arrested manner. So originally, I was arrested on manner 24/5 manner. These are the orders manner that has been passed by the court.
What about CD?
CD was called for that we have not received.
And only one submission matter. As because the case is pending here, matter, the court below matter had granted bail to other person. That order also I had.
No, I did not understand. So because the case is pending here.
Yes, matter. It was moved earlier here, matter. And the some other co-accused matter, who had approached the court below matter, they have been granted bail matter. That is the order matter I have passed.
No, you had passed, what are these orders?
But these orders are, matter, first I was arrested on 24/5/2023, matter. And in that case, my lord, originally, my lord, in that case, I was granted bail. Subsequently, another my lord case which I have been shown arrested, that was also allowed by this court, my lord. But subsequently, my lord, this case was filed, my lord, diary was filed for my lord. Now, my lord, the other co-accused person whose bail petitions were pending before the court below, who had approached the court below, my lord, they were granted the bail, my lord. So that's why I am praying bail for this person.
Yes, what is it?
He was so arrested on 17/6/2023.
That's, yes, my lord, but
His body also called, this study was called for, he was the shortage of it.
this ordered,
How many bail petitions have you filed?
my lord, here, my lord, originally, first one, that is B. Puria, my lord. That was the original case which I was arrested, my lord. Here, my lord,
The CD has, we call for the CD, no?
Yes.
Let the CD be called for.
no, my lord, the other two agents have been granted bail by the court below. As because this case is pending here, my lord, and that was not allowed. So we cannot move also there.
So we close it, you go and move.
Yes, sir, then in that case, not allow me to move it.
No, we can close it. How is, what else can we do?
Yes, but not allow me to withdraw it. I will.
All right, at the request of Mr. NG Doctor, counsel for the petitioner, who submits that he be permitted to close this bail petition, not press. He has instructions not to press this bail petition so that he can move appropriate application before the competent court. Accordingly, this BA petition stands closed.
But I have applied.
Both the BAs,
No, but I am appearing on item number 1.
item one closed, yes.
So far, I think it was confirmed by as my item, because it was my listed as my item number was my listed as by order.
CD,
CD. It is on worship,
It is already my on 18th.
27, fixed on 20.
no,
Matter is already fixed on 27. Accordingly, matter will be listed on 27.
or no.
Item 3.
Again, 439 application. NDPS 21A, filed in case 2070. 40 days behind the bar.
All right, call for
CD.
CD.
Somebody was yesterday, but not
National taking up from me.
let the CD call
yes.
for CD. When did you get it?
I'm not sure. 21 of.
21 July.
21.
Third direct councils. All for city. 21
Yes.
July.
Item 4,
Pilot case, this one, Sona.
Third direct councils. All for city. List on 21.
21.
Much obliged, your lordship.
item 5,
If you look at lordship, 439 day application lordship. The petitioner is in sale lordship.
Also, all for
Yes,
city.
section
All
12
for-
lordship. And 354 the penal provision for lordship.
We'll call for city. We'll call for city.
Short time maybe. 31 days I am in jail lordship. 11.
Third direct councils. Call for city.
On 20th of July.
20
22.
2007.
item 6,
Pilot case,
Third
this
direct
one,
councils. Call for city.
yes, what is?
Coming from.
What is here? Railway station.
24th of July.
24. 24. Why 24?
Early lordship.
Then 21.
21. 21?
Yes.
Much obliged.
City.
item 7,
Yes.
State judge may be called from another.
Third direct councils. Call for city. List on 24th,
26th of June.
26.
Yes.
item 8,
Only city. Medical.
Another medical option on 61st.
Third direct councils for the parties. Call for city. With medical and 164 statement. List on
Not sure, 25th of July.
25th.
item 9,
We have application in connection with the case number 96 of the 2022. In this case, lordship, the co-ed is something released by the honorable court by order dated 28 lordship 6 2023. Lordship, these are the orders. Lordship, all the co-ed have been released and case that is
Call for city.
city is available.
Where?
Here, lordship. Also in item number 65, it was confirmed. Can we get together?
Take it up with 60. What, which item?
65.
All right, we'll take it up with 65.
Yes, I have.
item 10,
Commercial particular already started the LCR scan of the LCR will be called.
The hard direct council for the parties. Registry to requisition. Scan copy. The LCR. And condition with. What is the case number?
Yes.
NDPS case number 42/23.
NDPS case number 42 of 23 from the Court of Special Judge Cohabitation. This upon receipt of this scan copy as called for.
Ask the parties before.
List on first ones.
item 11,
Of the industry for last 139 days. Under the displacement of the honor of the draft has not been made prosecution. Has not been arrested.
Yes, call for report.
I have received a report from Aya.
Hmm.
I have received a report from the Aya. Here in this case, commercial quantity 450 litres of ganja was recovered from the truck. And
They're what? What are they? Driver?
he is a driver and he is the brother of the owner of the truck. And the owner of the truck approached the honorable court by filing anticipatory that was rejected on 19 sheets. And another accused, he also filed application that was also rejected by the Honorable Court. And both the accused, they accepted that they were carrying the narcotic. They were supposed to be delivering to one person in Bihar.
This was with regard to one Mr. Lasu.
But still, he was also supposed to be arrested, but he approached this Honorable Court.
He was granted bail.
No, so this,
Interim.
no, it was both the application, one by Jaykumar Chauhan was the clerk of the honor. He also, the application was rejected on 1906. And the application of Lasu was also rejected this one. Yeah.
So what do you have against them now?
So now also will file final complaint within a statutory period.
When is the statutory period?
180 days. 139 days, 139 days.
But 180 is the outer limit.
No, what's it? Because 4 persons were yet to be arrested.
So
Investigation continuing.
in so far as these persons are concerned,
What's it? We have to file a composite not in part.
you expedite the investigation.
What's it? That is already in process. And after rejection of this bail, what's it? NCR is trying to pay these 2 persons.
From your report, in so far as these 2 people are concerned, their requirement is not available.
No, what's it?
You are making allegations against Jay Prakash Chauhan and the Lasu.
No, what's it? Here is 2.
These 2 persons were in the truck where the contraband was recovered. They were caught, arrested, they were admitted.
Yes, what's it?
Now what more do we want?
3 persons where they disclose the name of 4 person, other 4 person. The person whom the contract was supposed to be delivered. And the person who has supplied the goods, contraband, is a lawsuit.
No, you have produced this report. I am going through this report and there are whatever details you have recovered from them is available with you. Now the question that you have to answer is what is the further requirement of their detention insofar as the investigation of the case?
The contraband seized from their conscious position on the petition number 1 and 2.
So you file your charge sheet, you file your final report, whatever you want to
That
do.
will file within statutory period.
No, within statutory period means 180 days. They're already, you're,
That's correct, but the nature of the crime they have committed.
is it a case that they are involved in other cases?
That
They're really, where is that finding here?
we have written to the admin.
No, in this report, where is that finding? This report,
That place it for other report.
is the final report. Place one composite report.
And
You are arguing that 37 will come in play.
yes, that
So where is the finding that on these facts?
we regard to this pertaining to petitioner. Because the contraband seized from their conscious position.
These are your submissions. Conscious possession, no conscious is a matter of trial.
Yes, absolutely.
Now, so far as the question of their release on bail. They having been in custody for how many days?
139 days.
139 days. What is the further requirement of detention is something that we were looking for in the report.
No, see, section 37 the count.
We don't have section 37.
That is the, not see,
Where is the information from the IO to say that on these grounds, section 37 explicitly talks about the bar.
no, see, because
There is no finding here that they were involved regularly, they were involved in other cases,
this is the initial report.
they were habitual drug dealers or something like that.
Now under section 37 lordships observation with regard to that they will not commit further offense. That,
We don't know, but that's what the law is. It doesn't debar granting of bail
Yes, lordship.
except for satisfaction of the
Yes.
conditions under 37.
Yes, lordship. Lordship.
The fact that they do not satisfy either of the conditions of 37 is for you to submit.
Yes, lordship. Because this is a preliminary report, investigation is going on. So whatever matters.
You get the report. They can get a better report. If you want. Mr. KL, Learned Counsel will produce a composite report in respect of the status of the investigation and the requirement of further detention, continued detention of the petitioners. As the prayer in this matter, as it is submitted by the Learned Counsel, that as on date, the petitioners are in detention for 139 days. List again on 18th July.
Item number 12.
Yes,
Well, the middle benefit. The FR. Is the 13.
will call for CD.
Can you see my
Charge sheeted.
No.
He's been charge sheeted.
No.
Our Learned Counsel call for CD.
Well, can you see one thing, madam?
Hmm.
Page 30, for the time you went on.
Yes.
I'm going to state that the below person has been so and so below. In school. It is custody by the last 26 for 23. 26 for 23. For last 70 days. For last 70 days.
Get the CD medical and 164 statement. CD medical 164.
Lordship, the matter has been solicited.
Charge sheeted.
Yes, charges are framed.
Is it?
Yes, but
Where have you stated that?
well, they are coming.
Lordship, when it's on page 25, Lordship. Already charges has been paid, 300 heads.
Your bail petition before the court,
27 million, page 27.
has it been rejected?
Yes. The not also 28 million. Considering the nature and gravity.
Sufficient material.
28.
Our Learned Counsel to the parties call for scan copies of the LCR of special POXO 98 of 2023 from the Court of Special Judge POXO Cohabitation. Let the scan copy be called for by the registry, matter be listed on 35th.
Item 13.
FIR is on page 7, but section 12. When we go to the victim statement, is there in the section, page number 7. This information is happening stop virtually stop. Custody. 3 years punishment is there, but in this section 12 and 54 is available. Considering period of detention.
The hard Learned Counsel call for CD.
No.
Even with medical and 164 statement is available. List on 18 July.
Item 14.
Make it a longer version, then come. Make it a longer version.
Longer. Tell us your date.
24th.
24.
No, not 20. 25th.
Not
Lordship.
Item 14,
14 city name calls for 14
CTV call for. Only city,
city.
we call for list on
24th.
24th.
item 15,
Page 9, my lord, can you see one thing?
Charge sheeted matter.
No, my lord. Your turn. Page 9, you can see. On 22/5/23, at about 10 AM, while I was busy working outside of my house. That was technically under my house. With a view to do some illegal.
Heard in the council parties, call for city. List on
Lordship, it's from Bujai Lordship. And it is 25th.
28th
Yes.
July. 28th July.
item number 16,
Here, figure out.
from motion,
This is an application under article 2 rejection.
How much cost are you willing to pay
No, I already paid cost.
for coming here? You have to pay cost here also. Yes,
Report number 2. They have filed candidates. They have record number, has defend number 2. The only, my lord, is, my lord, our prayer was that, my lord, there was a lot of allegation made in the claim. That there was a collision,
you were defendant too.
I am defend number 1.
Defendant one.
And so far as my lord, already rule 1 is in Ocean movie to the directory. The body has got some judicial discretion matter. And when the order was passed, nothing was, my lord, considered, not even when that was discussed, simply on this, on the receipt of arithmetical calculation. My lord, order was.
Who is for the plaintiff?
Indeed, no one know agreement. Who was very lawsuit.
Disposed of this matter. But unless you serve copies, advance copies, they are not represented
Difference copy 2,
to the plaintiff.
they didn't find any agreement.
It's a different issue. But notice will have to go now,
My lord,
but will not issue stay.
no, stay, otherwise, my lord, matter is kept on 7.
That is why we wanted you to find out why you did not serve advance copy. You know
So they are the pilot.
the urgency.
That's true, my lord.
You have come before the court seeking an opportunity to file.
Registry also, my lord, did not say so, my lord. Registry also.
The registry will not say you are here before this court praying for another opportunity to file WS. Your statutory period is there. It is not a case that before 90 days this order has been passed. You knew it.
May kindly, my lord, grab this stay, my lord, of 7 or 8. Next petition for Oshme fees matter, I will supply the copy to you. Thank you. Otherwise, they will proceed expertly.
Counsel for the applicants. This petition is filed by the petitioner so and so, applicant so and so. Sorry, you're a petitioner so and so. They agreed by the order dated 02/06/2023, passed in TS 80/2023 by the Court of Civil Judge number 1, Gabru Metro 14. Also, the following order was passed. Extract this order. So, there are learned counsel for the petitioner submits that the bare perusal of the order reveals that no reasons are cited for rejecting the application, praying for extension of time for filing the WS. Also, the defendant number 2, who also earlier did not file the WS, Earlier
Yes.
was imposed the cost of rupees 5,000, it was permitted to file the WS. Also, however, there is no reason as to why the competent court did not permit the defendant number one to file the WS beyond the statutory period, beyond the period. And why no reasons are cited while rejecting the petition number 3360/23 filed by the defendant number one, namely the petitioner here. Learned counsel for the petitioner submits that next day fixed is 7/7/2023 for framing of issues / ADR. He accordingly submits that the impugned order be interfered with and the petitioner be permitted one final opportunity to file the WS and contest the case accordingly. Mr. S. Mitra
Respondent number 2.
appears for the respondent number 2. Who's the plaintiff here?
Respondent number 1.
AGM infrastructure.
All right, we will permit you to just tell us how much cost you want to pay. Having heard learned counsel for the parties certified that the impugned order dated so and so has rejected the application filed by the petitioner, being petition number so and so, praying for adjournment for filing the WS. Also. That counsel for the petitioner submits that one final opportunity be granted for him to file the WS and so that the matter does not proceed ex parte against the petitioner. But what about the ex parte order? There is already an ex parte order.
That is the respondent number 3. What is the number 3?
Defendant 3. Accordingly, upon hearing the learned counsel for the parties, this court is of the view that the criminal petition can be disposed of at this stage by disposed of at this stage. So the petitioner will file the WS. When can you file it?
Within 2 weeks.
Give us a date. Give us a date.
Give a matter on July 8, 19.
The petitioner, learned counsel for the petitioner has submitted that he is positively filed the WS within by 19th July 2023. And therefore, this court is of the view that the impugned order dated so and so is hereby set aside. The petitioner is permitted to file the WS on within so and so, subject to payment of a cost of
5,000.
5,000.
Already we have 500. That will be imposed by learning child court below. Already we have paid
10,000,
5,000.
7,000. Subject to payment of a cost of 7,000. CLP petition is according to dismissed in the disposal of the above.
All right.
17.
There's a caveat. Caveat discharge, not learned counsel. You are who's filing caveat?
I was the caveat.
Okay, not learned counsel. Caveat discharge. Yes.
Item 17.
Yes.
So the petitioners are engaged in business of transportation of LPG methods through tank. Now, one vehicle is treated as two loads, kind of, the capsule and the vehicle. The petitioner for the 10 vehicles had obtained 20 loads from the ICS contractor. During COVID-19, my lord, and expert, there were some irregularities, they filed a recovery report have happened.
In deemed order is at 63.
Yes, my lord, that's 63. My lord, on an off day, and on the basis of an application, you will kindly see the application, my lord, which is at page, my lord, 650, 60.
60.
60.
Yes.
I'll just read, and its application has been filed by the respondent bank, and surprisingly at 62, your lordship will find not even the affidavit, the paragraphs are not filled up. And only on the basis of this application, my lord, and what is page 60 for a moment, if your lordship comes to the prayer portion, what is the prayer of the page 60?
Yes.
In the premises aforesaid, it is therefore prayed that your honor may kindly be pleased to allow the urgent hearing in the matter and further be pleased to attach the account of charges. And this was the only document which was before the recovery officer, and the affidavit at page 62, your lordship find the paragraphs are not filled, nothing is there. Now on the basis of this, page 62, lordship will find, and on the basis of this application itself, the impugned order has been passed without hearing the petitioner. And this order has been passed, my lord, without any application of mine, because at second paragraph, third paragraph, your lordship will see, it is observed from the petition and relevant record, page 63, my lord.
Yes.
It is observed from the petition and relevant records filed by the certificate of so and so that CD is maintaining account number. So where is the record, my lord? Which record has been filed by the respondent bank or the petitioner? It was only on the basis of this application. And last line, lordship, is Roman 2. Provide last 5 years statement of above referred attached account to the authorized officer of next. How the
What is the direction? Is to create a lien.
attach the accounts and to file it to net fee manner. How the net manner, that fee is no way connected with this application, with this case manner. Provide last 5 years statement of the above referred attached account to the authorized officer of net fee or by email to so and so. Net fee is no way connected with this application, and this order of attachment has been passed only on the basis of
This was filed by the bank
by the bank.
in which you maintain the account.
Yes, to attach the account.
Better counsel to the parties for condition. This the CRP petition that we filed receiving the order dated 26/2023 passed by the DRP Guwahati.
Recovery officer 2. Next is recovery officer
Recovery officer 2. Recovery officer 2
2. DRT
DRP Guwahati in
RC
51 2022. No, this is passed in the OA.
Out of OA, this RC arises.
RC
This
51
is the type of execution.
2021 in OA number 5508 of 2019. Learned counsel to the petitioner submits that the petitioner is firm engaged in transportation and on necessary application for assistance for smooth conduct of their business. The respondent bank has sanctioned 20 loan accounts, various dates, and necessary loan documents. Also, it is submitted that because of the COVID pandemic situation, they suffered certain losses in the required installment amounts in respect to the loans would not be deposited within the prescribed period. Also, this resulted in their accounts being declared as NPA by the creditor bank. Also, The matter traveled to the DRT and applications were filed by the bank praying for recovery of the amount of rupees 2,155,81,213. The same OA filed with the bank
And with the bank.
is numbered as OA 508/219. Also, the petitioners attended the hearing and then contested the case by filing a written statement and evidence.
No, it was an ex parte order, we filed an application.
No, in the OA,
Yes, in the way it was an ex parte.
in the OA,
In OA, it was because in COVID-19, this order was passed, we had filed an application for vacating, and that is pending. And
no, you come to pay para 5 for your petition. Okay, you prayed for some time.
we paid for some time. Before pandemic, we entered appearance, and thereafter in pandemic, the places were not taken up.
The petitioners entered appearance in the OA number 508 to 2019. However, because of the COVID pandemic situation, the WS with evidences, etc., it will be filed. And adequate time was prayed for before the tribunal. Also, while the matter was thus situated, the recovery case being RC number 51, 2021 was filed before the DRT by the respondent bank. And the review order dated so and so.
620,
Whereby the following directions were made. Page number
63.
page 63, Roman 123. Also. There are learned counsel for the petitioner submits that the appeal order was passed without even not issued notice.
Nothing like it.
Even
The same day you
even without putting the petitioners to notice. Also, that apart, they had virtually repaid most of their loan amounts outstanding in respect to the loan accounts. Therefore, all these vital facts were necessary to be placed before the court, and the court, the tribunal ought to have given opportunity to the petitioners before passing the order with the directions mentioned in the same order. Being agreed, the present petition is being filed, where having heard learned counsel for the petition, let notice be issued, returnable 2 weeks. Steps on respondents by registered post AD, trustees also committed. Steps within 1 week from today. List the matter again. 19th July. Impugn order dated so and so shall remain state with the next.
Can it be 18 on 18?
18 July, impugn order dated so and so shall remain state with the next.
18.
On the
last occasion, I think on 23/6, a report was called from the police officer, whether they at all require the vehicle for
Do you have it?
investigation. I don't have, today I have checked, the report is not with us today. And I don't see even an intimation had gone, because I have to check, because normally they write, when they write it to the police officer. So Lordship can take it up on the next stage.
The vehicle was seen on 27 feet with
What vehicle?
Vehicle, of course, vehicle,
What vehicle?
central Lordship.
and in this case, it was carrying those drugs.
21 B Lordship.
You get the report. When can you get it?
On the next day, not the day after, on the next vacation court also, we can get the report. Hello. Anyways, by following Ambalam Sundarlal, that Supreme Court case, that can be given. But since a report has already been called for, so I'm saying. On 11th, I think there is a vacation court.
Jahan APP done APP submits that the report call for from the Okisto PS in connection with Okisto PS case number 164 of 2023 under section 21 small b/25 of NDPS Act has not been received. The matter being listed again on. Give us a date. Next. When is the next vacation? 11th.
11th, I think, 11th.
11th.
No?
List on
11th.
11th.
Positively on 11th.
11th, enabling her to obtain the required police report as called for.
Item 19,
There is an order saying it will be listed after summer vacation.
We have carried the entire proceedings.
No. There is a last order 27/6
Yes,
where it says list this matter after summer vacation.
I have mentioned it, madam,
Why?
significant, because there is a date of 7/7, that's why
7/7.
we will report below. Correct?
What is your challenge?
I carry the proceeding of 406, that is the husband don't like. More other two,
On the last day were you not present?
I was not present, madam. I was in court number 2, that's why.
Yes.
So
What
I
are you
said
challenged?
that, I'm even that the disputed fact matter that 482 own this is 482 own lie like the husband as per judgment of effect and our own high court also given several judgment. But my something I want to return it, my lord. But in the meantime, the two of the accused person, my sister-in-law, they don't reside in my house. They have been made accused, my lord. And moreover, my lord, I pray that the direction will be given to the local jurisdictional police officer to make an inventory. Fine, I return the goods, my lord.
You are agreed by which order?
I have challenged the entire proceeding, my lord.
So what is the last order passed?
Last order I have annexed, my lord. Page 25, my lord, can you see?
So 7/7 is for appearance report.
Yes, that's why I want to challenge it, my lord.
Your challenges is
Or
okay.
if you lost the issue notice, I have got no objection.
No, we'll issue notice.
Yes.
You take steps. But learned counsel for the petitioner. This criminal petition is filed by the husband.
Yes,
By the husband. What is your name?
Mangal Chauhan.
Mangal Chauhan. Being aggrieved by the complaint case number 195C of 2023 filed by the
Wife.
complainant wife as well as the order it is 6/6/2023 passed by the court of JMFC Courtroom, whereby summons were issued to the petitioner. Then his sister. Who are the persons?
There's a sister-in-law, there is a separately.
Sister-in-law,
Yes,
both sister-in-laws
yes.
to the petitioner and his sisters-in-law. Most of the matter is fixed on 7/7/2023 for appearance report show wasn't filed. Let notice be issued. Steps on the respondent by registered AD. You want to take Dusty also?
No, madam.
Registered AD. List again on 18 July.
Further proceeding is taken up. Till that.
Learned counsel have been heard of the interim right upon hearing the learned counsel for the party. This court is of the view that further proceedings in the matter be stayed till the next returnable date based on 18.
item number 20,
It was more into application matter. There's an FIR matter. Number 376 matter. Subsequently, one of the investigative agency matter and find charge sheet matter. And also we find the charge sheet at page 21, where I have been shown as an abscond. Page 21 below, my lord. Status of accused, my lord, absconder, my lord. What should I see in that, my lord?
Page 21.
21 below, my lord. Status of the accused, my lord. Roman, my lord, absconder, my lord. Now, my lord, what happened, my lord, in this case, my lord, the informant, my lord, who is a major, my lord, and admittedly, my lord, we had a illicit relationship, my lord.
Where is the FIR?
FIR, your lordship will find at page 10, my lord. That's the type copy, my lord.
Page 10.
Page 10, my lord. Now you are watching the time to page 24, my lord. The chart sheet, my lord.
Yes.
Page 24, my lord, below, my lord, is, that is, my lord, 17, my lord. Facts disclosed during investigation, my lord. During investigation, I have visited the company, draw up a rough statement, and the examine the complainant and other available witnesses and recorded statement under section 161. I will send the victim to the so-and-so hospital, my lord, medical examination and recorded her statement under section 164 before the Honorable City Court, Nalbari, and all of the copy of statement where she corroborated the case of the FIR. IO, my lord, this is the important one. The IO collected the medical report of the victim from the concerned hospital, where from the concerned doctor opined that were not consistent with recent sexual intercourse. That is done, madam. Now, madam, what happened, madam? The victim, madam, has filed an affidavit, madam. That your lordship will find at page 25, madam, the very next page, madam.
Yes.
Page 25, madam, here sworn an affidavit, madam. Paragraph 3, madam. I had a good relation with the accused petitioner in this one since long back.
Yes, madam, yes.
At this stage, I have issue notice.
Notice me, do let her come and appear. Because 376, of course, decisions are there, these kind of offenses cannot be. Cannot be.
Either way.
Either way, yes, cannot be, but no, if there are no chances of anything, then.
Yes, petition to file with the petitioner. Praying for washing of the charge sheets. Where is the charge sheet?
Charge sheet starts from page 17, madam. 17.
Charge sheet number 407, taken 28/04/2018. Filed by the IU in connection with Nalbari PS case number 316. What is the PS case?
PS case is Nalbari PS case number 316/2017.
2017. As well as the order. Where is the order?
Order, madam, I have not received, madam. Only the summons were issued. I went to the court.
So what is the case number?
Case number is PSC number 1090.
And the competent court has taken cognizance, then the matter is presently pending before For which court?
Before Nalbari, Citizen Nalbari.
For CPM Nalbari and as PRC number 1090 of 2019. Also, and a learned counsel for the petitioner submits that the FIR dated 17/5/2017 was lodged by the informant making certain allegations against the petitioner of commission of rape. Also, the state FIR was registered as Nalbari police case number 316 of 2017 under section 376/506 IPC. Stop the learned counsel with the petitioner submits that thereafter the charge sheet was filed where the petitioner was shown as an absconder. You were absconding, so you were shown as absconder.
I was very much there. I have
Yes.
Prayer is only to the extent of absconding. Prayer the person.
Learned counsel for the petitioner submits that that he was very much present and was available for cooperation with the police, for cooperating with the investigation conducted by the IU. However, for reasons best known to the IU, he was shown as an absconder. Also, learned counsel for the petitioner submits that the court, competent court, has issued summons in the matter. Also, learned counsel has also referred to an affidavit stated to have been executed by the informant. It is available as at annexure 3, page 25 of the documentation. Also, it is submitted by the state affidavit. The informant has stated that because of certain misunderstandings and quarrels with the petitioner on 15/5/2017, the FIR was lodged. Also, however, the matter has now been amicably settled outside court, and they are maintaining good relationship with each other. Also, it is further stated therein that since the FIR was lodged due to misunderstanding, the informant will have no objection if the charge sheet is squashed. MS Jahan and APP submits that at this stage notice the issue.
She should come and say if there is
The
some.
informant should appear before the court and make necessary submissions in support of the affidavit stated to have been executed by her. And accordingly, having heard learned counsels for the parties, let notice the issue. Returnable provides steps on the respondent. Since Ms. MS Jahan appears for the respondent number 1, notices away, however, extra copies be furnished within 1 week from the date. Steps on respondent 2 by registered in post ID within 1 week.
and Dusty.
And also Dusty is also permitted. Place the matter after 4 weeks, give a date after 4 weeks. 4 weeks,
10th of August.
10th of August, till the next returnable dates. The further proceedings in PRC case number so and so shall remain safe.
And DP of it. And a small correction, I think it will say JMFC Nalbari, not CPR.
Pending PRC pending before JMFC Nalbari.
And DP of it,
Not again.
and DP of it.
Item 21.
Yes.
This is an application for anticipatory rape. Because the petitioner is an employee under the BTC, as the OST to the chief executive. In matter relates to about 2015 and 2016 irrigation, when he was not even in the BTC. he has already appeared once when he was called and he has and gave his statement. In the FIR itself, your lordship will find three things.
Yes,
One, the proposal is related to certain irrigation scheme. And the funds come from the.
where is the FIR?
And that has been filed below subsequently at page 20 or what you will get.
Page 20.
22. It will be a separate additional affidavit, you know, part of that, because at the time when we moved, it was not available.
Yes.
You know, because if you're watching.
Yes, yes.
Additional affidavit page 20. I'll just summarize, it's a long FIR. I will summarize a few things, which I find from the FIR itself. First of all, it relates to 2015, 16 and 2016 and 17. The proposals came from the concerned engineers. The head of the irrigation department examined the proposals. He found that they're viable. He sent it to the chief secretary, who on his turn, granted the administrative approval. Thereafter, the entire proposals and schemes were sent to the central government because the funds will come under Article 275 under the subtitle of tribal funds. So it was sent to them. So the secretary, it is on record in the FIR itself that the secretary of the irrigation department will explain the schemes and everything to the central authorities. Thereafter, it was taking time. Therefore, one of the engineers who knew the petitioner, who was at that time working in Delhi, to pursue and see what can be done. Beyond that, he has no other role, and when it was ready, it was given to him, which he got the sanction order, which he emailed in his own personal mobile authority at BDC. Therefore, from that also it is clear that he has nothing to do with the either the sanction or anything at BDC. And the thereafter, after getting that, tenders were issued. The people submitted bids and the contractors were selected. The work is almost complete and they are asking for money now. And nothing bills are not paid. That is the whole problem for them. And petitioner was called, and he appeared before the IO on 15/6/22. Then subsequently a notice again came. But there was some problem in that notice.
There's some sanction order which is fake sanction order.
It is normal. Tribal Department, Government of India. That's what I was trying to see, that if it is of that, it was a fake sanction order of the central government. How the police get to examine possibly, or they will find out also, that's a different matter. But so far my law is concerned, it is admitted that I was an outsider and it is mentioned in the FIR itself.
How are you connected with these orders? What is your role?
Except, at page 26, it was option C, in the FIR itself, they have referred that I am an outsider and engaged by one electrical engineer at paragraph 11, page 26.
So outsider means?
Outsider means, he is not part of BTC at all. He doesn't stay in BTC nor does he work in BTC. Now he has come in 21 as OSD to the chief executive officer of BTC. But at that time, in 2015 to 17, he was in Delhi. He was not part of BTC. And it is mentioned in paragraph 11 at page 26 that one of these Biswajit Sharma, who was an then an assistant executive engineer, irrigation, Beasley subdivision, and there is one outsider, Sri Gitatha Borua, for pursuing the sanction. That is the road. He was assigned that it is pending here, it is taking time. This fellow was known to him, he said that you are in Delhi, you can see. And he didn't take any active part. As soon as the official orders were handed over to him, he emailed in his personal mobile. And if he had done something in the matter, it is inconceivable that he would be sent in his personal mobile.
Yes,
And that is mentioned in the FIR itself. And the only thing they are saying that para 13,
so at this stage, a 41-day notice is issued.
yes, and I have already appeared once. Second time, if they fixed it on a date of 22, they have realized that it can be done. So they have yet to give me a further notice to appear. So I am prepared to appear, that I have said. I have nothing to hide. I have already appeared once. I will appear again. And once your lordship is aware of 41A also says that if you are cooperating, then you don't have to be arrested. I am there. Your lordships are fully cognizant of that position. That the whole purpose is to ensure that he cooperates.
Now, why are you apprehending arrest? Because 41-day notice,
Second time it is coming. That's the
second time what is coming? The notice.
because this notice was given, which is at page 13, because. But the date your lordship will see, there was a mistake in the date, that's why they said that all right, you don't come.
3006. 11/3/22.
It will be
Page number 13. So 13, you were asked to appear on 3006.
23/6/22. Because lordship just see, there is a obvious mistake. I was really, but
Page 15,
page 13, because
13.
1-3 is the type copy of the original, which is at page 15.
Yes.
And all that they say,
You were asked to appear on
that there
30.
is reasonable ground to question you to ascertain facts and circumstances from you in relation to the present investigation. Hence, you are directed to appear before me at 10 AM on 36/22. 22, the notices of 23, therefore there was an obvious mistake. They have realized, therefore they have informed the BTC that he did not come and they will give a further date subsequently. That has not yet come. But I am prepared to appear before them anytime they give me a notice.
Yes. What do you have to say?
Once I have appeared, again I am free.
Malak, here, there are 44 numbers of Malak, the sanction order, which have no any existence. And their sanction order has been, Malak, they have allotted the cost, work has been executed, bills have been prepared. And
Who issued the orders?
Malak, from the, yes, even from the, Malak, the FIR, you also be paid on the page 10, page 25, there are 10. It's start from 9, para 9. But also
No.
paragraph 9.
We have seen, we just wanted to know from you, from who has issued these orders? Is the
Well,
central government?
Central
Central
no,
government.
there is central government, there is no any such sanction.
These orders are shown to have been executed by the central government, shown to have been issued by the central government.
But here,
Para 5 for a minute, page 24 of the FIR. It is mentioned, during inquiry, it is found that the schemes were shown sanctioned by the following sanction orders released. Orders accorded by Nadeem Ahmed and the Secretary to the Government of India, Ministry of Private Affairs, New Delhi.
Or did you get your instructions?
yes, madam, the case is necessary in this case, madam. And moreover, madam, here also we see, here this person is, madam, the paragraph, madam, 10. Para 10 of the FIR and page 26, madam. The relevant para start from page 26. Here, my lord, the Territorial Council, Kokrajhar, no checks was website of the Ministry of Tribal Government of India. Other team made criminal conspiracy with Vishwajit Sharma and Sri Gidartha Darshan Bora, the present petitioners. And many prepared a fake sanction order with their unknown ill motive as well as used the fake.
Where was the petitioner at the relevant point in time? Where was he posted?
He was not in BTC.
He was now.
Posted in
Now, then,
then.
where was he?
My lord, that's why my lord, case there is necessary. Where was he at the point
For
of
the
time?
case that-
But his conspiracy was similar by the co-accused. His bail application was moved before the honorable court, my dear Sarkar. Here it's clearly seen, my lord, these after perusing the case that is revealed, my lord. This Sarkar, he hates a criminal conspiracy one with.
All right, you call for the CD, heard?
My lord, by in meantime, my lord, no interim may be.
PPA was forming under CD council assisted by Mr. Vicky Kora, Mr. Fukan and Fukan, another APP of the state. Call for CD. This anticipatory bail is filed by the petitioner apprehending arresting and in an FIR dated 26/07/2022. Lodged by the informant who is the Deputy Superintendent of Police, Chief Minister Special Vigilance Cell. Also, the same FIR was received and registered as Vigilance PS case number 02 of 2022 under section of judgment. It is submitted by the London Council to the City Council for the petition that there are certain allegations made against certain other persons in respect of some sanction, some irrigation schemes where 24 numbers of irrigation schemes where fake sanction orders were stated to have been issued. Also, the works were also stated to have been executed in an amount of rupees 58,65,75,630. Worth of financial liabilities have been created. Also, during the course of the investigation, as is revealed from the FIR, there is a reference of the petitioner number of the petitioner. Also, Learned City Council submits that during the course of the investigation, upon the notice being issued under section 41, capital A, he had appeared before the authorities concerned. Subsequently, another notice was issued to him, which however,
They did not, they informed BTC that there is a mistake there.
however, he was directed to appear. However, in the same notice, he was directed to appear on 30/06/2022. Also, the notice was admittedly issued in the year 2023. Therefore, the petitioner was informed that he did not appear in pursuance to the same notice. Also,
BTC was informed, who informed?
the petitioner was informed through the PTC. Also, the petitioner is presently serving as an OSD
OSD to the chief executive.
to the Chief Executive Officer, BTC. CEM is operating as is working as OSD to the CEM, the PTC. So, another senior council submits that there is an apprehension that he may be arrested in connection with the investigation of the same case, and therefore prayer for anticipatory bail has been made by way of the instant petition, where Mr. M. Fukan, the PP appears and submits for CD will be necessary in this matter. He objects to the prayer for anticipatory bail and submits that Other co-accused were appeared before this court.
My lord, yes, his bail was rejected.
His bail was rejected by a court and bench of this court. Also, they submitted that the allegations made in the FIR are serious and the punishments prescribed. The allegations made in the FIR against the petitioners are serious and the offenses as alleged are grave and the punishments prescribed if convicted subsequently are severe. Most of the therefore submits that petitioner ought not to be granted privilege of anticipating. Having heard learned counsels for the parties, let's CD the call for. Anything else you want? Only CD.
My lord, only city, my lord, no evidence.
Only CD. Petitioner, in the meantime, will however continue to cooperate with the investigation. If he is directed to appear before the IU.
Whenever it is.
So, when can you get the CD?
My lord, after immediate reopening of the.
Let the matter be listed again on 18 July,
Not yet.
18 July.
Not.
Till the next date fix, no coercive action against the petitioner. Prayer for interim will be considered upon perusal of this.
My lord, not of it.
Prayer for anticipatory will be.
No course of action.
Not of it.
Item 22.
Online.
Yes, so next.
My lord, regarding serious of this difficulties, my lord.
24 if it is.
24th, this one 20.
Not of it.
Yes,
May I please interrupt? Lordship, this is a 438 in petition, Lordship, the FIR
439,
438 question.
38, yes,
The FIR starts at page 14, Lordship.
yes.
The grievances of the complainant is this, that 3 persons have used the
FIR is at page
page 14, Lordship,
14,
1/4.
yes.
The grievances of the complainant is this, that 3 persons have cheated the complainant and on the strength of some documents, land documents, have entered into an agreement to sale. And they have taken an amount of these 48 lakhs 55,000 from the complainant. And hence, this is the case, Lordship. Lordship, the petitioner, Lordship, is a very, is an innocent person. He is not, his name is not mentioned in the FIR. And Lordship, in fact, he himself is a victim of this, of the FIR and accused person. Lordship, kindly see page number 17 and page number 23. 23 is the vernacular part. Lordship, the petitioner, before the Lordship is a sub-register. And Lordship, these FIR and accused persons have approached the petitioner also, and they have cheated him. And Lordship, at page 17 can see the application for registration of document with permission. Lordship, I was cheated, Lordship, and hence I allowed the registration of this document. Lordship, apart from this, Lordship, I have no role, Lordship. Lordship, in a similarly situated situation, Lordship, one of my colleague, the circle officer, Lordship, he approached this honorable court.
Who are you?
Was granted.
Who are you?
I'm the sub-register, Lordship.
Sub-register.
Sub-register Pujari. Lordship, election E and F.
Yes.
Election E and F.
What he says in his petition is that he was supposed to send those documents when he was he was summoned. And he could not send it because
Get CD, get the CD. Heard learned counsel. Yes, you are also appearing in the matter.
Yes, sir, losses, I have a big case of the circumstances here, you must see. But if I see my instant case, I will.
We call for the CD.
In the meantime, protection will be given.
Because
We
the,
call for the city.
no interim in my submission because,
After 2 months, I will get return will be yours. After 2 months, that's
because
why protection will be given yours.
the only excuse that he is saying is that computer was not working and he couldn't send the documents. But under section 91, he was asked for the documents by the office.
You call for this,
No,
we call for the city, heard
In the protection will be.
Mr. So-and-so learning counsel for the petitioner. And Ms. So-and-so learning APP for the state. This one is very various filed by the petitioner. So-and-so who has. Who is apprehending arrest. In connection with. What is that case number?
Case number
Ojai BS case number 256
256.
of 2023 and the section 12. Also, it is submitted by the Internal Council for the petition that an FIR dated 19/5/2023 was lodged by the informant one Nishant Agarwal, making allegations that a plot of land measuring about 6 acres in Gola Ghatia Basti in Ojai was purchased by the informant from
From a lady who actually was imposted.
was
From a fake lady who was, it turned out to be a fake. Yes, this is what.
probably married by the name MS and so from one lady.
Yes.
She was accompanied by 2 other persons and on their assurances, the agreement was executed. Common sale permission was also obtained for transfer of land from ADC to Ojai. Also subsequently, when the land was sought to be registered, it was revealed that the lady who presented herself to the owner of the land was an imposter and had fraudulently executed the sale agreement and took away payment of rupees 48,55,000. Also, the allegations were primarily directed against 2 other persons, namely one Jagannath Roy and Mohammad Zakir Hussain, who had introduced the lady to be the owner of the land to the informant. Also, subsequently, the lady was not to be traced out. Although they said Sri Jagannath Roy submitted a power of attorney scheduled to have been executed by the lady in favor of Sri Roy. Not Roy, Ray. Ray White. Ray. So, on these allegations, the FIR was received by the Ojai case number 12. So, here are the learned counsel to the petitioner submits that he is the sub-registrar in the district of Ojai.
Yes, I will get that after 2 months.
Who had registered the sale. You registered the sale.
Yes.
Then what happened?
Then 91, under section 91, someone was issued to give those documents, he could not. And saying that there was a technical failure in the computer section.
Lordship, I am seriously sorry for I don't Lordship. There is a praise. Lordship.
Now in addition to computer, you have eye problems.
Yes, that is also Lordship.
And then you'll say since in 2 months you're retiring, your memory is also fake.
I will fully cooperate with this property loan.
No, you will cooperate provided the documents are available. If they're not available, I have to cooperate. Learned counsel for the petitioner submits that because of certain technical defects, technical issues relating to the system failure in the district administration, the relevant documents could not be produced in response to a summons received by the petitioner under section 91 CRPC. Also, Learned counsel for the petitioner submits that as he was unable to produce the same document because of system failure in the office of the district administration, he is apprehending that he may be arrested in connection with the same case, although he is no longer in Iran. MSS Jan Leonard, APP submits that the CD at this stage we call for.
Technical failure cannot continue for so long. We could have sent it out. So,
Most of that servers
And the prayer for anticipatory bail be considered upon perusal of the CD as called for. And I having heard learned counsels.
protection will be made, we see we can lose it. Already one.
We allow me to directly pass the order first,
Oh, that's it, that's it.
or you give us a type copy, we sign it.
No, that's, sorry.
Let CD be called for. In connection with so and so case. In the meantime, the petitioner is arrested, he shall be released on condition bail on the 30,000, one local sale to like upon the satisfaction of the arresting authority. Subject to the following conditions, he shall appear before the IO within 7 days. He shall not hamper or tamper with any evidence, and he shall not intimidate or influence any person or witness connected with the case, and he shall not move out of the jurisdiction of OJPS without written permission of the IU. It is taken on
any date in the August 21st,
21st August.
Item 23.
Yes,
On page 9 of that section 11 particular when the particular commitments.
we'll have to call for CD. this
In
thing.
the meantime,
In the meantime,
can we see?
serious allegations.
No, madam, can we see the irrigation, madam?
Now,
He was not there. He went out.
how?
With a bad intention, whether this girl entered into the shop of the petitioner, madam. To take it away.
From the affair, how can you?
Madam, I stated in my petition, there are 5 minor can kindly make it. 5 minor, page 3. The girl is received as collector, madam. She taken mobile from the persons and stolen books and copies from
How do you know all that? How do you know all that?
The inquiry reveal everything, madam. In the meantime, madam, you have protection, madam.
she is a 12-year-old girl and
Very good.
mischievous nature, loving and
And madam, can you see, she entered into the shop of the petitioner, madam.
Oh, they still
And
the same.
petitioner, without knowing, madam, he locked the door and went for marketing, madam. Now, after some time,
You did not know the girl was inside.
No.
They locked it from outside.
Yes, we are hiding somewhere for bad intention, madam, to take something out from the shop or.
I heard Mr. India, even it comes to the MS.
See, they will reveal everything, madam.
APP for the states. This anticipatory bail is fine with the petitioner, creating a risk in connection with. What is JMK? Jamunamukh. PS case number 2929 of 2023 under section census. Read with section 8 also. Parallel and counsel for the petitioner submits that he is a businessman who has who runs a tea stall. What is a tea stall? Also, the daughter of the informant is known to be a person of doubtful character who was previously engaged in a number of criminal activities, including stealing mobile phones from our books, household items, etc. It is submitted by the learned counsel to the petitioner that the allegations made in the apparent false, concocted, and no such thing happened. Rather, the daughter of the victim girl had concealed herself in the tea stall. And when the petitioner closed his shop and went out for shopping or purchasing some items, she raised a hue and cry. And then the father of the victim girl was reapplied, making false and concocted allegations. Let's see the report. Along with medical.
Along with the medical, her statement will also be there.
Along with medical and our statement
164.
under section 164. How soon can you go?
On 18th or 19th of July, this month?
17 will let us see.
17th of July.
Allegations are there.
Any day, no objection by.
19th, sorry, 17th.
In the meantime,
17th.
I have some protection, my lord. In
Tea
the meantime,
That tea store cannot be so big that he didn't see the girl and he locked the door. It's very difficult to believe. Let the city come.
the city
Otherwise,
will
we'll
be
be here
available
for
to me. City will be available.
Therefore, we consider,
Just, something.
we consider your prayer upon the city being called.
In the meantime, my lord. He's an old man, my lord.
How old is he?
And. he's a
55 years old.
55.
55 is old.
55 years. 60 years retired.
You are posing serious worries for us.
My lord.
55 is old.
17th. after
Village man, my lord.
17th.
Some protection, my lord. Some.
In the meantime, the petitioner is arrested, he shall be released on furnishing a bail bond of rupees 40,000, two local securities of that amount, the satisfaction of the arresting authority. And subject to the following conditions, he shall appear before the IO within 7 days from today. He shall not tamper or tamper with any evidence or intimidate any person, nor move out of the jurisdiction of Yamuna PS without written permission of the IO. Let
Only
me
my objection can be this
The-
jotted down.
learn
Because 12-year-old girl.
learned APP has seriously objected to the grant of anticipatory bail, interim protection. Also, however, considering the fact that the protection granted to the petitioner is only an interim protection, continuance of the interim bail will be considered upon perusal of the CD to be
Alright.
received on, listed on then 19th,
19th of August.
19th of August,
Or July, yes, July. 19th of July.
19th July.
I will not be there, my lord. Because
He wants a longer day.
I went for my treatment, my lord. It's a fact, my lord.
26th of July.
I expected I will come.
21st of July.
I will come
21st of-
at 21. Expect me.
All right, then 23rd of July.
23rd is a Sunday, 24th July.
All right. No, no, not July, we're talking about August,
Oh, August,
23rd August.
August.
Lordship.
Item 24.
Next is your lordship. Lordship, this is a 438 date application to petitioner before your lordship. Lordship, the FIR lordship will sign on page 13 lordship. Can you see that lordship date of FIR and lordship for the incident lordship? After 20 days lordship, this FIR was registered lordship that on page 13. Allegation against the petitioner number 1, that is the accused number 2 lordship. Accused number 1, that is here this. The informant wife lordship committed suicide lordship. Now this informant suspect this involvement of this petitioner lordship. It's clearly stated that lordship she has committed suicide lordship. And whatever lordship I have stated in the paras 5 in page 6 lordship, this petitioner number 1 had a relation with the informant wife lordship 1 year ago lordship.
He is your brother
Petitioner number 2 is the brother lordship.
of 1 and 2 are brothers.
Yes lordship.
Yes, madam.
Lordship, in fact, there is a reason given in the FIR that some delay is caused. So as far as delay is concerned, there is a reason.
Or the police station is only 6 kilometers from the place of occurrence.
But page number 14, it's written, we were busy in cremating the dead body,
That
and so
cannot be
there is
taken 20 days lordship.
delay. And father, he was
Let's have
coming
the
with
CD,
her,
let's have the CD and PF.
but 302.
In the meantime, also I may be protect lordship. If it is a case.
Council for the petition parties. This AB petition is filed by the petitioner apprehending arrest in connection with Yalmari PS case number 35 of 23 under section 0. Another council for the petitioner submits that there is no allegation against the petitioner in the FIR. However, he is shown as an accused person. Also. The daughter of the informant committed suicide.
Wife.
Wife of the informant. And it is alleged that it is alleged that the informant suspects that his wife did not commit suicide but was killed by the accused persons, namely 1 and 2. The accused persons 1 and 2 named in the FIR. It is so and so that APPs for the state submits that the allegations in the petition are grave and serious and therefore preference ought not to be granted without prejudice of the CD. Having heard and encountered the parties, let CD along with PA report call for.
20th of July.
In the meantime, if the petitioner is arrested, it shall be released on furnishing a bail bond of 30,000 with 1 local security of like amount, subject to the satisfaction of the arresting authority and subject to the following conditions. He shall appear before the IO within 7 days. He shall not tamper or tamper with the evidence. He should not intimidate any person or witness, and he shall not move out of the jurisdiction of Yalmari police station without written permission of the IO. Let's begin on. Tell us a date.
Any date in the August, 17 August or
17 August.
Idea of it. Okay.
Item 25.
The petitioner is the father of the boy. The son is already arrested in connection with this case. A 64-year-old person. The girl is as per the
64-year-old, very old person.
no, not very old person.
No, 55, somebody very old.
Earlier case.
So 65, 4 months, very old.
No, involvement it is because the son is already arrested, but the girl is of 17 years was it as allegation of the FIR, those he.
Yes, yes.
Only the date of birth of the father is the father.
Son not the.
What is the name of the person?
There are
Son is already been arrested in connection with this case.
You abandoned your son.
No, he's been arrested in custody. Yeah, out of half of a day, you can, they got married. So then, she become pregnant, we have got no option, also, we can take house.
How old is the girl?
Girl is, as per the allegation, LS FI option, 17 years.
the document for the next.
Blooded councils looking facts. Therefore, is an anticipated debate between filed by the petition that apprehending arrest in connection with Chapel PS number 69 of 2021. Under section so it was mentioned. So the petition will be put this forth. Is named as an FIR and is named as an accused person in the FIR lodged by the informant. Also in the state FIR dated. What is the date of the FIR? 2/2/2023. Will allege that the accused person number 1 named in the FIR and married his daughter, had forcefully married his daughter. The informant is not the father.
No, there's some other person.
The informant
It's a format.
lodged by the informant who has alleged that that the daughter of one Sri Ainol Talukdar, who is about 17 years old, has been married to the son of the present petitioner Bilal Hussain, who's about 20 years. And she was married off, and it is alleged that she was married off by her father in lieu of money, which was promised, which was offered to her parents. So, learned counsel for the petitioner submits that the son of the petitioner, who is named as accused number 1 of the FIR, and the daughter of and the girl who's named in the FIR had a relationship, and they eloped and got married in private. Most of the petitioner or any of his family members are not responsible for conducting the marriage of his son with the same girl. Also, as such, the allegations in the FIR in respect of the petitioner are false and contrary. Also, it is further submitted that the person who lodged the FIR is not a relative of the girl or her family members. Also, there are Mr. Sharma. Sorry, DP Goswami, the DP of the state submits that at this state the CD, along with medical report with the DP called for. There are having heard that it consists to be partners. The CD called for along with medical report and statement of the girl under section 164 CRPC. Also, in the meantime, if the petitioner is arrested, he should be released on furnishing a bail bond of 30,000 with 1 total security of life bond and subject to the following conditions. He shall appear before the IO within 7 days. Rest of the conditions list on 17th August.
Much obliged, much.
Item 26.
Additional lordship, the FIR is not named in the FIR. The FIR person will be taken into custody. Page 9 is the FIR.
The allegation is that, my lord, they have detained this person, my lord, and taken away money, case under 395 and 490 and 120B. 348, they do 25A IA of the Arms Act has been registered against all the accused persons. We also will find that my name is nowhere in the FIR. But police asked me to attend the police station, my lord. Out of fear, I have come before you. I think I go, I'm ready to cooperate with the I want to pretty much proper.
Our other counsels for the parties. This anticipatory bail was filed by the petition apprehending arrest in connection with the whole yes case number 117 of 2023 and the sections. Learned counsel for the petitioner submits that by FIR dated 26/5/2023, lodged by the informant, allegations were made that he was waylaid and robbed by showing pistol and assaulted. Also, his mobile phone was snatched away and about 85,000 rupees have been transferred from his GPay account. Also further, an amount of rupees 35,000 in cash was taken in the payment. Also, his mobile phone was subsequently broken and he was allowed to go on at about 2:30 AM in the morning. Also, learned counsel for the petitioner submits that he is not named in the FIR, nor are any allegations made against him. Also, he, however, apprehends arrest as the police has asked him to appear before the police station in connection with the investigation of the case. Learned counsel for the petitioner submits the petitioner is not in any way connected with any of the allegations made in the FIR. According to he apprehends arrest. He therefore apprehends arrest as prayed for the anticipatory bail. Whereas Mr. Goswami submits that CD being called for in the matter. Whereas accordingly, let CD be called for in the matter. In the meantime, the petitioner is arrested. He shall be his own furnishing a bail bond of 30,000 with one local security like amount, satisfaction of the arresting authority. And subject to the following petition, we shall appear before the IO within 7 days, and the other conditions. List on 17 August.
Item 27.
This is 439 way of things. The FIR starts for base 10. But also may kindly below the started from base 13. May I read you?
Yes.
Most effectively, a vehicle stated, I, MM Muzumdar, son of the resident of Courtroom, resident also during the district of Kanye. Do hereby inform you that I have personally put up and measuring two purpose bearing card numbers 1378 and Pata number 518 for reference for village and Kobita Council, who were residents of Dev Sutal under Ramsoni in the year 2011. Therefore, I have raised that and bringing the station in my name. Today, 26/23, there is Tuesday, I, my wife, Srimati Manasi Muzumdar, my elder brother, Vivian Muzumdar, younger brother, Ruben Jyoti, Ninku, well, to my plot of land. However, Kunoni Council, wife of Professor Council, the present Petitioner had stopped us at the entrance of our land by FPA Imbu fencing as far as we were beaten, and Clothing Council saved us with the cow in our hand in order to take our rights. Moreover, the thing was given that our vehicles will burn down. On the other hand,
We will call for the CD. Right, Mr. Learned Counsels. Call for CD. When can you get it? Also. When can you get it?
21 July.
21. Sorry, 21.
at Union 3 also, I think about 39. It's an adjustable bail application, you know, the doctor in law. Yes, may I pay the CBB protected in this case also.
Connected arising out of the same
Same case also.
39. 39. Same police station.
Same police station, same case, Your Lordship. She was not arrested. But she is named in the FIR, Your Lordship. May I please receive the petition?
Yes, Mr. Repeat. Same PS 179.
One thirty-nine.
Heater in 39. You appear within 7 days. List on 17th.
This
Item 28.
Both matters on 17th.
17.
17 August. Yes, 21st. Already, 21st. Yes.
And five also you can swear for. Irrigation has been given.
Quick call for CD.
Monetary transaction was there because the informant also he himself sold out as per the allegation. Also we can see they have already sold out that fake currency as a allegation. And the rest of two are arrested. She is last lawsuit working under the SDGM. Kindly protect our lawsuit. These are false allegation. Of monetary transaction is there between their lawsuit, not regarding that allegation. There he is also offender lawsuit. We will look into the allegation. False allegation. Somebody have given an idea of it, so he had 5 days. So otherwise, there is monetary transaction within their lawsuit that is different issue.
You introduced.
No, then after lawsuit, he is also offender lawsuit. He is also offender.
Actually, what a fake currency lawsuit.
No, he is also offender lawsuit. He said earlier lawsuit that round he have already sold out in the market.
Therefore, CD.
Any lawsuit, she is a working as a government employee lawsuit. Any lawsuit. No, absolutely false allegation. She will reveal everything. And let me appear one.
She is what? Accused one.
Accused one. She is a last lawsuit.
So
Kindly lawsuit protect her.
she decided
No, absolutely false allegation. She will.
nursing fake currency is more beneficial than nursing patients.
Absolutely false allegation. Lawsuit and take it to the true lawsuit. Then
How is it false? We have specific. Why is the informant inimical to you?
But some monetary transaction was here between them. Some monetary, that is the portion of that. Some monetary transaction was there not to this context. Yeah, absolutely false. Can you?
Our London Council School Party score for CD. Petitioner is apprehending arrest in connection with. What is your case number? Here we go, PS case number 83 of 2023 under section 12. So it is submitted that the petitioner is an employee, is a nurse and presently working in the office, working under the SDM and HO. There we go.
Lawsuit.
Also, an FIR dated so was lodged by the informant, making allegations that the petitioner, along with her brother and another person, had arranged for some fake currency upon taking money from the informants. However, in spite of the informant having paid the amount as directed by the accused petitioner and the other accused persons, the fake counterfeit currency notes were not delivered. Also, it is alleged that the accused persons are involved in the counterfeit in supply of counterfeit currency notes. There are learned counsel of the petitioner submits that the allegations are false, and there was some monetary transaction between the petitioner and the informant. However, these allegations of the petitioner introducing the informant to a supplier of counterfeit notes is totally false and not based on any material. So, also the petitioner, the learned counsel to the petitioner submits that she's employed as a nurse. She appears arrest in connection with the investigation of the same case, and therefore has approached this court and praying for investigatory. Mr. Goswami learned submits that CD and FSL. What? FSL will be necessary. Then with FSL report for. Having heard learned counsels with the parties get CD along with FSL report we call for. In the meanwhile, the petitioner is arrested. She shall be released upon condition paid on rupees 30,000. With one local security of like amount subject to the following conditions. She shall appear before the eye in 70s. She shall not emperor or tamper with the of the evidences. She shall not intimidate any person or witness. She shall not move out of the jurisdiction of their counties without the information of the written permission of the IU. Let the matter be listed again on
Much obliged.
21st of August.
Much obliged. Much obliged.
Item 29.
May I prepare the Cohabitation and Allegation. After phase 10 logic. Logic after laws after 10 days of the incident. The matter was due to using the headlight in upper condition. It was the rainy day, rainy light logic. The informant come from the opposite side and using the headlight in the upper condition. And after that, I was fall down in the road, and one were between each other. The matter was negotiated at police station on the same night. Again, after 10 days back, the affair has been like.
Yes,
Serial injury for which
but learned counsels for
In
funds.
the meantime, I may be protected.
This anticipatory bail is filed by the petitioner apprehending arrest in connection with our PS case number 52 of 2023 under section. Also by the FIR dated 24/04/2023. It was alleged that it was alleged by the informant that the accused persons had assaulted. Accused persons 2 and 3 assaulted the informant and caused grievous injury and looted an amount of rupees 1,35,000. The apprehending arrest, the present anticipatory bail has been filed. Mr. Goswami, the DPP, submits that CD along with the Indian report be necessary in this case. That I having heard learned counsel's parties call for CD along with the Indian reports. In the meantime, the petitioner is arrested. He shall be released on furnishing a bail bond of rupees 30,000 bail bond will still be by the month. The satisfaction will be arrested subject to the following conditions. It shall appear within 7 days from today. And then the other conditions. Based on 21st August. 21st August.
Item 30,
Page 12 is the allegation. Here, 9% were found to have been fishing in the Kaziranga National Park. Others were so they are on interim paying money. Some of the 80%. The others are the next month. Start from page 14.
Yes.
Page 14 is the order of the co-accused manner. Accused number 3, 4, and 9 are on interim. Page 13
Your name will be FIR.
Yes, FIR name 3, 4, and 9 are on interim.
No, your
No, I have 1 month.
one.
Papu months. And three for similar order.
Yes.
My lord, kindly have my lord the offense report, my lord, because he is the accused number 1, my lord, this complexity, my lord.
Similar allegation. Similar allegation. No difference. They were
Content may be given, my lord.
may be given, because
What about the other matters? They are fixed
they're fixed, madam.
on.
No man at all. On man at all.
Heard the council parties. This. Anticipatory bail is filed by the Petitioner. Apprehending arrest in connection with. What is the case number?
My man, WR 01
WR.
01 oblique 2023 dated 18.
WR 12. I think it is WR 12.
Page number 12.
WR 12. Okay. WR 01 of 2023, dated 18/3, 2023. Under section 51. No, under section. What is this? 27.
22nd
27, 23, 31, 32. And
and 52.
52 of wildlife protection. This section. Learned counsel for the petitioner submits that. You are not fishing.
No, not picking, madam.
What were you loitering?
I don't think I myself personal because captain the camera, madam.
But Kaziranga is closed, you can go in there as a tourist.
One of VBS in the neighborhood.
Neighbor. Learned counsel for the petitioner submits that some persons were found to be fishing in the inside the Kaziranga National Park. And the range officers and wardens upon coming to know when to apprehend these offenders, and in the process raise the hue and cry. Petitioner who's a resident, petitioner who's a resident on the outskirts of the Kaziranga National Park, from hearing the hue and cry, went to find out, inquire as to the cause. However, subsequently came to know he was also named as one of the persons who is alleged to have gone fishing inside the Kaziranga National Park. Also, apprehending arrest, the present application is filed. But counsel to the petitioner is referred to similar orders passed by other coordinate bench in respect of other co-accused named in the file. Also, there are Mr. Sharma,
Yes, madam, special PP available.
the special PP appearing for the special PP wildlife. Submits that case diary we called for. Do we call it case diary or report? Offense report. We call for in this respect. Where having heard learned counsels for the parties, yes, the offense report in connection with so and so case we call for. Meanwhile, if the petitioner is arrested, he shall be released on furnishing a bail bond of rupees 40,000 with one local security life amount, subject to the following conditions. Petitioner will appear before the eye within 7 days, and the other conditions. When can you get it? When are the other matters fixed?
They are 4 days, not after 4 weeks. But in the August,
23rd of August.
okay.
Item 31.
Attendance is 16. 169.
Yes.
But the petitioner is not named in the allegation that Malad one. While taker is seized by the police party, they suspect to be a crude oil which is taken from the.
Why are you apprehending?
I'm coming, Malad. Thereafter, Malad, the petition was taken by the police Malad to the police station, Malad. And then he was served after interrogation, the approximate time was 18, 180. He was served with a notice under section 91 CFPC, Malad. And he was directed to produce 2 mobile handset with SIM card. Here, Malad, got in the bottom, Malad. Details of articles required. 1 mobile handset, 2. And number 2 belongs to the petitioner, Malad. Number 1 does not belong to petitioner. Then, Malad, from 19, 190. The petitioner submitted this letter, Malad.
Yes.
In 19, Malad. Which refers to the subject cited above. I was ready to submit my SIM card number so from the telecom company. Airtel later so with my secondary transfer since 15/6/2023 to the IO of CPS at Lankasi outpost, but petitioner received the same. Further, I regret to inform you that the required article being number 1, which mobile insert number 1, so by neither in my possession. Note
Then what happened?
then, Malad, I have produced my mobile insert. Then again, Malad, page 20, Malad. One another notice is served to me, Malad. Then again, they want to this other mobile and insert and SIM card mirrors. Then page 21, I have replied to in detail everything what happened, Malad. Thereafter, I filed one bail application before the letter sessions in Malad. Document kindly comes to page 25, Malad. In that case, income was granted, then Malad, page 25, Malad. Malad 26/6/23, Malad. I'm reading from the third paragraph.
You tell us what happened after that.
Malad, document kindly see 26, Malad, page 26, Malad.
You granted interim.
Interim, then Malad, page 25, order, Malad, my bail was rejected, Malad. On the ground, Malad, document kindly directed on page 26, Malad. Page 26, Malad, from perusal, may read, Malad.
Tell us what is there. Why do you have to read it? Why don't you tell us?
Malad, court find that this petitioner has appeared before the IO, but he has not produced his up-to-date bank passbook, Malad. As well as Malad, the SIM card which police required, Malad. And Malad, the court further found that this petitioner has monetary transaction with one Rakesh Singh. So the bail application was rejected, Malad, page 27 on last paragraph, Malad. On two counts, Malad. First, we had a monetary transaction with Rakesh Singh, Malad.
Who is Rakesh Singh? One of the accused persons.
One of the accused person, and he has not produced a SIM card. Then, Malad, this Rakesh Singh has filed one bail application before this honorable court, Malad, page 29. Now, this Rakesh Singh bail application was closed, as nothing was found against him in the case diary, Malad. Page 29 is the order, Malad. Relevant will be page 30, Malad. Paragraph 4 and 7, Malad. It is learned that there are no allegation against the present petitioner, so the question of granting of clearance bill does not arise at all.
But this petitioner is operating all around, and another we take it to operate.
Learned counsel for the party. Yes, Mr. Our letter counsel for the parties, this anticipatory bail petition is filed. The petitioner apprehending arrest in connection with Insukia PS case,
Or to be PSS.
all to be. All to be PS case number
67 of 2023.
67 of 2023. Under section 22. Learned counsel for the petitioner submitted that an FIR was lodged by the informant, who was a sub-inspector for general manager security of Oil India, making allegations that they found tanker, oil tanker, bearing number, page number 16, number legal, bearing number so and so, was found to be laden with suspected crude oil, approximately 9,000 liters, which were pilfered by installing 3 tapping points in the 8-inch COD line connecting Makun to Cohabitation junction point. Also, during the investigation, the petitioner was asked to produce, issued a notice by the IU to produce 3 mobile handsets with SIM cards, bearing numbers so and so, page 18. Also, it is submitted by the learned counsel for the petitioner that he produced 1 mobile handset which was available with him and registered in his name. However, in respect of the other mobile handset and the same card, he submitted that the same is not available with him. This was informed to the IO by communication dated 18/6/2023. It is submitted that apprehending arrest in the course of investigation, the petitioner approached the filed a bail application before the additional session judge to FTC. Also, although the Court of Additional Session Judge to FTC had granted interim bail, however, subsequently the same was rejected. Also, learned counsel for the petitioner submits that coordinate benches of this court had granted bail in respect of other persons. Learned counsel for the petitioner submits that the Court of Additional Session Judge to FTC had rejected this bail by observing inter alia that he was in where is that observation?
Page 27, last paragraph.
That there was some monetary transaction with co-accused Rajesh Singh, alias Rakesh. And his bail application was accordingly rejected. Also, it is submitted that the said Rakesh Singh had approached this court by filing AB 2103 of 2023, praying for anticipatory bail. Also, this coordinate bench of this court by order dated 19/06/2023 closed the bail petition by recording the submission of the learned APP that there are no allegations against the petitioner upon perusal of the scene. And as such, the question of granting pre-arrest bail did not arise. When a learned counsel for the petitioner submits that in that view of the matter, the rejection of his bail by the Court of Session Judge, FTC 2 in Sukia was not called for. And consequently, he is before this court, the protection of anticipatory. Mr. Sharma, Goswami, an APP submits a CDB call for this stage. Then having heard learned counsels for the parties, get CDB called for. And in the meantime, the petitioner is arrested. He shall be released on furnishing a bail amount of rupees 30,000 with one local security applying amount, the satisfaction of the arresting authority. And subject to the following conditions, he shall appear before the IO within 7 days from the date. And he shall not hamper or tamper any evidence or intimidate any person or move out of the jurisdiction of what is the police station? Waldo police station. Without written permission. You take permission.
He will not take the jurisdiction.
You appear before the IO within 7 days, take permission. You are being given the permission, you will not move out without written permission. Okay. List on
22nd of August.
22nd August.
Okay.
32.
But this is also arising out of the same PS case matter. The accused is different matter.
Accused is different.
Accused is different arising out of same matter. In this case, the brother of the petitioner is already arrested matter. Some co-villagers were arrested. That's why they have taken.
Yes, Mr. Goswami.
So he is the brother of the arrested particular case that is called.
Yes. List again, list on 22nd along with AB petition. Is there we call for interim? Within 7 days before the IO.
33.
Yes, Mr. Solomon. The reason that there is no 438 and that's why we is not tail line. The allegation is that my last I should inform and keep made by the accused number 1, 2, and 3, and 4, my lord, in the instance of the part of accused number 1. And subsequently, my lord, that matter accused number 1 in the name by granted bail by the penalty edition of disputed session.
Yes, Mr. Borwa CD and medical.
No, my lord, I don't know what 38 where is the exchange the subsequent level is that it was granted bail only, but then the penalty was also filed. We should warrant issue lordship, so we should appear lordship. There must be some appearance on lordship.
You are number 3.
Yes.
Accused number 3.
2 and 3.
2 and 3. Two and 3. So what happened? Charge sheet file.
I'm still in the trial, and the trial has already been arrested and subsequently granted bail.
You have not appeared.
No, my lord. So on 11/11/2019 was granted bail. So my lord, and I'm already been my lord, the patient has been registered, and available warrant has been issued. So my lord, my lord.
Then we have to call for the scan copy.
No, my lord, I will it is not required. So all you say the other someone has been issued to him for his appearance. Available warrant. Available warrant is whenever he will appear, he will be allowed to go on bail. It is not non-bailable warrant. Let him appear. The trial court definitely will consider. Only that observation should be done by the trial has already been granted bail. So my regular bail should be considered. This is the only thing.
We can. There's nothing wrong in saying it can be considered, but we can't say it has to be granted.
No, consider. Because the trial has already been granted bail.
I heard learned counsels for the parties. Heard learned counsels for the parties. This anticipatory bail petition has been granted, has been filed by the petitioners 1 and 2. Apprehending arrest in connection with ER case number 5044. Arising, relating to the previous case number 1664 of 2019. Is submitted by learned counsel to the petitioner. That pursuant to the FIR dated. Where is the FIR?
Yes, they will.
FIR dated 21/09/2019, lodged by the informants making allegations against the accused person named Barry. A case was registered, case was registered as PS case number 1664 under section 1664 of 2019 under section so and so. Petitioners are named as accused numbers 3 and 4.
3 and 4.
In the state of fire. Subsequently, upon due investigation, charge sheet has been filed by the IU before the competent courts. Learned counsel for the petitioner submits that the prime accused in the matter has already been enlarged, has been granted bail, has been enlarged on bail by order dated 11/11/2019. Also, the petitioners have now been summoned to appear before the competent board in the
PCL case number 448.
In special case number
448.
448
2022.
of the 2022. Also, learned counsel for the petitioners submits that they apprehend that upon appearing before the court, they will be arrested. Also, Mr. Borwa learned APP submits that his apprehension is misplaced, as the petitioners have not appeared, responded to the summons and appeared before the competent court. And also, under such circumstances, the petition is not maintainable. Having heard learned counsels for the parties, this AV petition, we close this petition. The AV petition stands closed, giving liberty to the petitioners to appear before the competent court in response to the summons issued in connection with special case number 448 of 2022. Also, upon their appearance before the court below, and upon filing any application for bail, the same shall be considered on its own merits by the competent court by taking note of the law laid down by the apex court in so and so versus so and so, Siddharth and others versus so and so, and pass appropriate orders in the said application. The AV petition is accordingly stands closed. Petitioners will appear. When is the date fixed?
1/8.
Will appear on the next on the date fixed by the competent board, which is 1/8/2023.
I think 34.
The application in the writing of the application document find that page 35 matter. Page 35 on word. Both the petitioners are brother. Page 34 I have given the type copy. From page 35 on word, there is one to that. The application has been circulated in the plan. That the petitioners are involved in Hawala transaction and international betting racket. Page 36.
E6, yes.
Page 39 also.
Yes,
So my lord, in view of the serious accusation, petitioner are appealing against. And they are not aware whether the FIR has been logged or not.
what is that earlier order that?
Earlier order, my lord, in the year 2021, the Hyderabad of Attack Police registered an FIR regarding breaking in IPL, and the petitioners were arrested. And they were granted bail.
Yes, Mr. Borua,
But this application is not maintainable also because there are no FIR has been registered also. They are apprehending it only on the basis of a TP report also. When there is no FIR, how he can apprehend it?
Yes, my lord, I am relying on the honorable constitution and decision rendered by the honorable Supreme Court in Group of Singh, India. The honorable Supreme Court has categorically stated that for land, information of the community, no, lodging of machinery is not a cement quantity. There are 30 seconds. Well, in this case, by the fact, Group of Singh, India was a minister, and there was acquisition regarding links involved in political corruption. No FI was not, but they approached the honorable Punjab and Haryana High Court. And the full bench of the honorable Punjab and Haryana High Court rejected the application of appropriate. But the honorable Supreme Court reversed their order. Procedural guidelines, page 37. And I'm given the judgment matter, 590, page 590.
yes,
Thirdly, the filing of a first information before we start the condition precedent to the exercise of power under section 438. The imminence of a likely arrest founded on a reasonable.
likely arrest on what basis?
Like based on this demonstration,
Somebody has to register some case. Why will you be arrested?
no, my lord.
What are the facts involved in this case?
So there are things I have already stated, my lord, that some clear business is bad. And some business people are trying to, my lord. That is how we made them empower business. And Lordship knows the supply element is involved in this case by the restaurant. And petitioner businessman, we have given our case registration certificate to NHB. When there is no chance of funding or anything like that. Since the acquisition is serious, our transaction and involvement in international betting like that. Some protection. There are 3 minus next of that case number. You mentioned secret, there are 3 incidents. You are the Minister of Power and Irrigation in the government. In fact, honorable Purvesh of Punjab and Haryana High Court recorded certain reasons by that. All the reasons were indicated. And one of the reasons that point number 7, you should find that reason that para 11 of the consent is 76. All this leads down to interpreting the honorable constitution.
You get your instructions and find out if there is any case or FIR or anything registered.
Why I can get those instructions. As soon as that without any FIR.
How do you know? That is what you are expected to get. You have to get your instructions and tell us that there are no case or FIR registered.
Let it be the after tomorrow.
Day after, I don't know when is the next available bench.
Or 11.
11.
I have a strong objection to this. In this type of cases, also, interim protection cannot be granted. I am not disputing the Guru Singh senior, but to also consider section 430 CRPC.
Yeah, it's a 438 application. Protection manual. Election people, they have given the what happens in the meantime, they will become important. In losses, everyone knows the surprise element is important surprise of election.
Therefore, we are asking him to find out as on date.
No, let them find out, but I'm not.
Find out.
At 2 PM of when get to the pay get started. Only at 2 PM.
I think 35.
In one case, I'm done a bail. There is another case pending. Can you even look at case 22?
22.
If it is reading totality, specific allegations against deputy Halal. Now he has been granted the privilege of bail, that order is I'll be touching 29. He has been granted the privilege, and 29. The one there are petitioners appear before the investigator officer within 10 days, failing which on the time from 11th day, this interim PLS bail order shall have no force. So that will expire, with all respect, on 8th. Now there is another case pending against same 353, and that FIR when seeking PLS bail, there is a case 13,
Is
Case 13.
1-3.
1-3. Only 353, In fact, the present petitioner was not there. His wife was there. Wife had some tussle with the police. And if it is ready totality, ready totality, I turned the page, Thereafter, it is stated, in the said incident, I, along with other police personnel accompanying, this is the language, police language, with me received injuries. SI Litumoni Sharma. And in the affair itself, the medical report of the lady has been given. That is at page 30, Page 30, First informant, subject accompanied by whom, the name and address of the injured person, Litumoni Sharma. Lots of a scene, Litumoni Sharma, emergency on examination, details of his chest pain, so and so. Nature of injury is simple. An opinion, I am of the opinion that there is no injury clinically,
Now, who is preferred the
He is already on bail, Can you protect me,
He is already on bail.
Yes,
In connection with one case.
The main defined case,
So this particular bail
This is the
application.
outcome,
This bail application, you are filing, apprehending, arresting which case?
In the present case, 353, where the lady is not injured, first informant.
Page number
Page 30,
30.
30. Litumoni Sharma, first informant, Name and address of the injured person. Emergency registered OP. The case number is same, reference, Belsor PS case number 244/22, 294, 324, 353, 34 IPC. Here I am seeking TLSB. Is injuries caused by nothing, opinion. I am of the opinion that there is no injury clinically. Because police, with all respect.
How many FIRs are filed?
2 affairs,
The first FIR is.
I got bail.
Where is the first FIR?
That I get out, Case 22.
22. This is registered as 257.
Yes,
And you are on bail by order dated 28/29.
Exactly.
Then comes the second FIR.
Exactly.
Page 13.
No. Exactly.
For which you are now seeking bail.
Absolutely.
Now, what is that injury report you have referred to?
Of the first informant, my lord.
Ah,
That to be 353, my lord, some government official has to be injured, my lord.
hmm.
She went that she was accosted, my lord. And then the medical report of the lady in question, my lord, the first informant, 30, my lord. This is the medical report, reading totality, opinion. I have the opinion that there is no injury feeling.
But this is with regard to also PS case 244.
Yes, yes, my lord.
Where is 244? What has happened to 244? The bail which you got is 257.
Right.
The present case is,
That's all 244.
this is the present case.
Yes, yes.
No, yes, Mr. Borwa.
My lord, immediately, my lord, that to be appearing for a trial court also. Because like the file page 20, my lord, the search that page.
Charge sheet.
Yes, my lord, I let you.
Let me appear for a trial court.
No, you are saying that in so far as the page number 13 FIR,
Yes,
that has also been charge sheeted.
yes, yes. Yes. I cannot go to give my statement, my lord, which will be inoperative on 8th, my lord. Because of the existence of the present case, we will be behind bars, my lord, that much. I should appear, my lord, and I have to go there.
That
That will
what
be
we
there.
consider.
Only for my protection, maybe.
What protection?
3 years, maybe. Other,
Pre-arrest bail protection, if it is given, then where is the necessity for you to go and again pray for bail?
that is not necessary for me.
So we are comfortable with,
3 years, maybe.
no, we are comfortable with directing you to appear before the
And my lord,
trial court and file a regular application.
in that event, my lord, we fall respect, my lord, we put behind my unnecessary, my lord.
We have given orders referring to the Supreme Court judgments.
Can it be in this manner, my lord? Because that order will be inoperative, my lord, protecting invalid, my lord. And let us scan to be this from my lord, that will be the fitness of the case. You agree, my lord.
All right, heard that counsels for the parties. This EB petition is filed by the petitioner apprehending arrest in connection with. What is the case number?
My lord, that is my lord, the first title, my lord, with all respect, my lord. My lord, PRC 452/23.
PRC 452
of the 23,
2020.
arising out of Belfort PS case number 244/22.
Arising out of Belfort PS case number 244 of 2022.
My lord.
Which is presently pending before the SDJM within bracket S Nolbury. Learned counsel for the petitioner submits that in respect of an earlier FIR, which was lodged by the same informant, which was registered as 257 of 2029. Coordinate bench of this court has already granted him bail by the order dated 28/06/2023 in AB 3740 of 2022. Learned counsel to the petitioner submits that he be granted interim protection and the scan copy of the LCR be called for from the competent court. Where Mr. Borwa submits that scan copy be called for.
Could be registered.
From the registry, be called for from the competent court. I think heard learned counsel to the parties, registry, requisition, scan copies of the LCR in connection with PRC case number 452 of 2023, pending before from the court of SDJ Sobel Nolbury, arising out of also PS case number 244 of 2022. Let the matter be listed again on 26th of July. Meanwhile, if the petitioner is arrested he shall be released on furnishing a bail bond of rupees 30,000 with one local civil to like amount, my satisfaction of the arresting authority. And he shall appear before the competent court as and when directed. And he shall not move out of the jurisdiction of the court of, you're a resident of where? Belfort, so nobody is out of the jurisdiction of the Belfort PS without written permission. Please take it on so and so.
It is not the case of the speaker. That as of now, since
We are not inclined to dispose of this application today. So what we can do is we can ask them to obtain specific instruction, fix the matter in the next available bench, you may argue. But I have gone through the judgment. I think para 35 and 40 is relevant for your purpose. Your apprehension must be based
yes, correct.
on some material which can be considered objectively by the court.
Very true.
So your apprehension as on day is on the basis of a news item.
Yes, acquisitions very not equal. Acquisitions are already there. What you will kindly time to take.
In a news item.
Yes, madam. News item. But acquisitions very not equal. Not only the news item.
No, correct. Accusations made in a news item is not sufficient to arrest you unless there is a case registered. Some proceedings.
I am trying to impress upon your objective, whether based upon the acquisition made in the news item.
The further view of the court at para 40
Yes.
is that granting anticipatory bail, even when in matters in like in Gurbakh Singh, cannot be understood to be a blanket order. Then no matter whatever allegations, whatever proceedings are there in respect of these accusations, you will not be arrested.
Now my humble submission before this honorable court is there. Why don't you kindly come to prayer 59? What you were saying can also be referred to it.
Yes.
Let us read it, madam. Prayer 35. Section 438, one of the code lays down a condition which has to be satisfied before anticipatory bail can be granted. The applicant must show that he has a reason to believe that he may be arrested for a non-bailable offense. Well, in my humble consideration, that is very important. The use of the expression reason to believe shows that the belief that the applicant may be so arrested must be founded on a reasonable ground. Mere fear is not belief, for which reason it is not enough for the applicant to show that he has some sort of vague apprehension that someone is going to make an accusation against him in pursuance to which he may be arrested. Here, my lord, accusation is yet to be made, but in my case, accusations have been made.
Come to the next slide.
Yes, madam.
Come to the next slide.
The grounds on which the belief of the applicant is based that he may be arrested for a non-bailable offense must be capable of being examined by the court objectively, because it is then alone that the court can determine whether the applicant has reason to believe that he may be so arrested.
Now let us pause for a moment. Tell me what grounds are available today for a court to examine objectively
Yes.
that you have a genuine apprehension.
Yes. In my humble submission, my lord, the police authorities can very well arrest me anytime based on the accusations that I have.
That can happen to anybody anytime.
Yes, madam.
In that case,
But there are specific that I am involved with, the petitioners are involved with.
this is an allegation made in the media. Pursuant to that, what materials do you have that on the basis of these allegations, an inquiry investigation is being initiated, which may entail your detention?
My lord, that inquiry or investigation will not be known to me unless I am arrested, madam. How can I be privy to such investigation, madam?
We are not convinced.
And just one question, if the lordship permits me. If my lord, my learned friend says that the police authorities cannot arrest the petitioner on the basis of the accusations level and the answer is not safe, then I will recommend it. But if the answer is affirmative, then in my humble position, the reasonable apprehension exists, that might not, this may be a risk.
We are going by the, you are relying on a judgment, we are going by the findings of the apex court. Then there must be some reasonable apprehension to be examined objectively. Now, what are we to examine objectively? Where do we get the material to examine objectively? Do we call for the information in the custody of the news channel to examine objectively? That is what is being discussed in para 35, followed in 40. That your belief is not equal to a fear. Your belief must be based on certain grounds, which grounds will be available for the court to examine objectively.
Kindly also see the facts of this case also. Here, my lord, CBI was a minister in that government. A power delegation, only accusations were made that he is involved in political corruption. And under no affair was done, nothing was there. So under that circumstances, he approached the Punjabi Haryana High Court under the same section, the single one, the honorable single referred the matter to the full bench and the full bench at para 11.
That apart,
Yes,
there are judgments where it says that in matters where you are not required to be arrested. There are provisions for issuance of notice.
yes, 41A also is there. So when they come to the provider of court has been named. Or once.
We are not convinced. If you want a disposal, we can dispose it off.
Also, I'll just refer to this provider and then I will come up my.
You are asking for disposal.
Watching may grant some protection, that is why.
You get your instructions.
My lord, my lord, I take.
You get your instructions.
My lord. For two police stations, I have told my.
Wherever to be 1, 200, 200 police stations, wherever you want to get your instruction.
Let it be on after reopening.
Not after reopening, let it be on 11th. After reopening, all right. Let it be on, give a date after reopening. The proposition which you are trying to make will change the course of orders passed under 438 by the court. I hope you realize that. If granted in your case.
My lord will kindly see the provider to 438. 438.
Yes.
In my book, it is my lord at page 236.
Yes.
Provided that when the High Court or as the case may be, the Court of Sessions has not passed any interim order under the section or has rejected the application for grant of anticipatory bail, it shall be open to an officer in charge of a police station to arrest without warrant the applicant on the basis of the accusations apprehended.
Correct.
Then in my humble submission, this apprehension persist.
No, these apprehension persists, but these apprehension has to be on the basis of, for us to objectively,
True, my lord.
objectively examine the matter.
Yes, but the accusations I have explained.
Hmm?
The accusations I have already explained.
The accusations are on merely some information on the news channel.
No, it's serious accusation, absolutely kindly go through it. But we are involved in Hawala conviction and international trafficking.
That will require an investigation.
No, I'm not saying that.
The investigation has to be on the basis of some information. So unless, if the police, let us say in a given state, the police ignores.
Right.
For the time being, it is.
Well and good, my lord.
Well and good.
But other way around, my lord.
If they don't, we are not closing your petition. You are entitled. Then under such circumstances, you may have a better case to say that yes, these are the materials, which is why I apprehended this.
I fully understand, my lord. I am the tax court, but we also will see the railway scouting authority protects.
It has to be decided on a case to case basis of the facts of each and every case. What is your nature of occupation? What do you do?
By profession, you are business owner, parasite, you are parasites of the application. And we have annexed the GST registration certificate and NHR3 policy.
To suggest what?
To suggest that we are doing business in that particular field. We have a shop named Grocer's Box, and we have another shop in the Central Mall Market, and we are also in contextual. NHR3 policy and the GST certificate is on.
When can you get the inputs? After reopening.
After reopening.
Our learned counsel for the parties, this anticipatory bail petition will be filed with the petitioner, apprehending arrest in the face of allegations made or slash telecasted in a local news channel, making allegations that the petitioners have links with international betting groups. Also, and Hawala betting groups and Hawala transactions. Also, learned counsel for the petitioner submits that the apprehensions, the effect of publication of such news items are likely are sufficient to cause apprehension in the mind of the petitioners to approach this court for a prayer for anticipatory bail. Learned counsel for the petitioner submits that under the provisions of section 438 CRPC, the court has ample power to grant anticipatory bail in the event of the petitioner expressing apprehension in respect of the allegations made. Also, that apart, learned counsel for the petitioner has relied upon a judgment of the apex court rendered in Sri Gurbakh Singh Sidia, reported in so and so. Relying on the judgment, learned counsel for the petitioner submits that the power to grant anticipatory bail is inherent in courts, in the courts, and the power under section 438 is wide enough to grant protection to the petitioners, grant protection to persons who approach the court claiming the privilege of section 438, and the registration of an FIR in such a case is not one of the conditions precedent of grant of anticipatory bail. So what is required to be observed by the court is what is required to be taken note of by a court while addressing a petition under section 438 is the existence of apprehension of arrest or being taken into custody by the investigating agency on the basis of certain allegations made. Where Mr. R.B. Borua, learned PPP, submits on instructions that he made that which police station?
CID and crime branch.
The CID and the crime branch, in respect of CID and crime branch, no case is pending against the petitioners. He, however, prays for further time to obtain detailed instructions in respect of the apprehensions expressed by the petitioners. Accordingly, he has agreed to by the councils that the matter be listed again on 19th of July, on which day, depending upon the instructions that may be forthcoming from the learned APP, the prayer for anticipatory bail will be considered. until the next returnable date. No coercive action will be taken against the petitioners without leave of the court.
No, we will be limiting here 19.
We are giving you a date earlier, you said after vacation. We can fix it on a vacation board if you want. You get your instructions. Where is the next vacation board? 6. We'll fix it on 6th if you want. It's for you to tell us when you can get instructions. 6, fixed on 6. Till the next returnable date, no coercive action be taken in respect of the petitioners. On the basis of the apprehensions expressed in respect of the allegations made in the so-and-so petition, listing and on so-and-so. 6th.
I will never be forgetting.
No, I have I do the instructions from only different police stations. Because I cannot know the different from
Let him get instructions. The interpretation which you're trying to give would be to take out, would be a situation where it would be advisable for everyone to approach the court and apply for a bail. Some apprehension may arise somewhere on some day under some police station.
In my humble submission, like I am getting because there is specific indication and police can arrest on the basis of.
Police cannot arrest you unless there is some materials, unless there is an investigation.
If this news item would have been followed by another news item that government of Assam has directed to initiate.
Why are you after the media? You get your instructions from the police and find out what they are up to.
Item 36.
Yes.
FI university has paid 16 university, operative part university paid 17. May university. With reference to the subject cited above, I make it say that the National Petitioner university have received they were not disclosed in the truth that he is a married man and has a wife living so and so and and that in the year 2022 in the month of April 28 by receipt for months he had a long relation with me and he used to come and stay at my house and since then we have been living together as husband and wife and have 4 weekend sexual intercourse with him. He is my husband and have made out declaration and benefit device from the mother and let us 10 day of April 2023 in an Indian money is counterfeit. When I was pregnant, I was and when I
Yes, Mr. Borua.
Lordship. In fact, your lordship, if your lordship comes to the next page.
CD and medical.
The medical report.
Yes, next page.
Next page, your lordship, the dates your lordship will kindly note 4/7/2022, 16/8/22, 4/10/4/23 at Bujai Hospital. Now, if your lordship comes to page 20, your lordship. Immediately after the 13 days, she has issued this legal notice to me. Now, your lordship, in the first, second, third, fourth paragraph, your lordship will kindly see. Date changed, your lordship. After 3 months on 7/7/2000, now it becomes 7/7. You took me to client at Goita Langsu from Bujai, it became Goita Langsu, and forced her to do abortion from pregnancy and she did abortion in a civil hospital at Goita Langsu. Then your lordship next phase.
Yeah, let us call for CD along with medical
In the meantime,
and
if the government can.
our learned counsels for the parties. This anticipatory bail petition is filed by the petitioner apprehending arrest in connection with
Phase 2. Yes.
Doc Mocha PS case number
29/2023.
29/23 under section so and so. It is submitted by learned counsel to the petitioner that an FIR dated 3rd of June 2023 was lodged by the informant. Made allegations against the petitioner that they used to maintain a relationship like a husband and wife and cohabitated with him. And a declaration to that effect, and a declaration of the marriage was also made on the basis of what is this notarized agreement? On the basis of an agreement executed on non-judicial legal stamp paper on 10th of April 2023. Also subsequently, when she became pregnant, the informant forced her to go for an abortion and consequently abused and physically assaulted her also. Learned counsel for the petitioner submits that these allegations are false. And therefore, and he has nothing to do with the allegations made in the FIR. However, in view of the investigations carried on by the police, he apprehends arrest and therefore has approached this court, filing the anticipatory bail petition. Para Mr. R.B. Bogor, learned counsel, R.J. Bogor, learned counsel for the petition for the respondent, submits that CD along with medical report and 164 statement if available would be necessary. Having heard learned counsels for the parties, let CD along with medical and 164 statement be called for. And in the meantime, the petitioner is arrested, he shall be released on condition of bail bond of rupees 30,000 with 1 rupee security in life and subject to the following condition. He shall appear before the IO within 7 days. He shall not hamper or tamper with any of the evidences or intimidate any person or witness or move out of which police station? Dock Moka police station without without written permission of the IO.
Yes.
Matter released on 23rd of August.
37.
Illegal person of the statement was seeking. In FIR, petitioner has not been verified. It is especially that has been registered as special allegation. And it is pending because of the violation of the factory that is committed in this case. The petitioner has followed.
You want to appear before the court below, or you want us to call for the scan copy? Heard learned counsel for the petition, which anticipatory bail petition is filed by the petitioner apprehending arrest in connection with
Special case number 20.
special NDPS case number
20.
28 of 2022. Arising out of what FIR?
Punari police station case number.
Chunari PS case number 06/2022 under section 17B of NDPS Act. So let the scan copies of the LCR be called for by the registry from the court of. Before which court? Honorable Special Judge Gwalpara. In connection with special NDPS case 28 of 2022. Please, after reopening.
Yes, I will protect it.
What's the kind of 34? 34 पास करेगा. May I read it?
Yes.
From the perusal of the case report, it also reveals that in the extent case, someone was issued to the accused person and after receiving the same,
He took two adjournments on 18/4/2023 and 25/2023 for his appearance. So prima facie, there is no any warrant issued against the accused person. Hence, in my considered opinion, mere apprehension of various without any warrant does not entitle the accused person to pay for allowing him to privilege of anticipatory appearance. What is the law in this?
Already on 1/7/2023, NREGA has been issued. That is the date of filing of this petition. Already been, I have instruction.
He has been issued
I
some more.
already put it.
You appear will direct the court to withdraw the NBW.
Yes. I have also annexed another order of this. I think bill has been granted. That is the question number 35 onwards. On the basis of in view of the seen.
We'll consider all that upon perusal of the case diary.
Yes, sir.
I'm sorry, the scan copy which has been called for.
Yes, sir. Well, I think the main thing I have to put it. This
Yes, Mr. APP.
My lord, there is no, my lord, wrong with the order. My lord, normally warrant has been issued, lordship, that is issued only because he has not appeared.
Have you filed any application for recall or cancellation of the order earlier passed?
no,
Arising out of the same case? Is it the same case or different matter?
no,
No, different matter.
Similar situation.
No, not similar situation.
In that case also, NREGA was secret.
Maybe we'll see after the
I am great for some great.
list on 19th. List on 19th. We'll call for scan copy.
I think 38.
CD. Third learned counsel for the parties. Anticipatory bail is filed apprehending arrest in connection with Courtroom PS case 143 of 2023 under section 20. Let's see the along with medical report and 162 statements under 164.
Possible time shopping video.
We call for. Tell us when you can call Courtroom.
14.
14th. 14th. Allegation court. 14th.
14 is the recognition.
13th. Right. 13/7.
I think 40.
After the case 11. Case 11. The allegation is under section 42409. That the allegation is that petitioner had misappropriated certain money from the customers. Now, so far this allegations are concerned, these kindly note, also kindly note the arthritis of 8 of April 2021. Now, in the month of May 2020, I make category statement in therapy. That now police has one of the all the petitioner overthrown. Asking him to appear before the IAEA. Here, petitioners submission is that para 5 and para 7. That particular period from 10 2021 to 16 2021, he was busy on leave in connection of delivery of his wife. And
So for taking money, it is, there are seven, my lord, it is the accountant, my lord, come the cashier, he is the responsible for taking money. Now, my lord, the informant and the, my lord, the accountant, my lord, this period which he was under leave, my lord, they might have, my lord, done something, my lord, but since, my lord, now the affair, on the basis of the affair, now petitioner has all, my lord, and now he, after 2 years, my lord, he has now the apprehension, my lord. So therefore, approach before the honorable court. For granting, so he will appear, my lord, he will cooperate with the investigation, lordship.
Let the case diary be called for examination.
Current learned counsels with the parties. This anticipatory main petition is filed with the petitioner. Apprehending arrest in connection with the Mongoldoy PS case number 152 of 2021 under section 20. It is submitted that in the fire dated 8th of April 2021 was lodged by the informants. Making certain allegations that the petitioner had misappropriated an amount of rupees 3,46,238. Post of pursuant thereto. Investigations at comments. It is submitted by the learned counsel to the petitioner that during the period when the allegations are made, the petitioner was on leave because of his wife was in the hospital for delivery of a child. Also, the learned counsel for the petitioner submits that he had all along cooperated with the investigations. However, he now apprehends that he may be arrested in connection with the so-and-so case. Where are you employed now?
Malad, he is a private service, Malad. It is another Malad. He already retired with effect from Malad. He resigned from that earlier office 16 to 2021. Now, Malad, he is at Malad Fundas Financial Service in Guwahati.
It is submitted that presently the petitioner is working in a different organization, private organization, and the allegations made in the FIR are false and in respect of which the petitioner claims to be not connected at all. Whereas Mr. Borua and other deputy submits that case that we call for. Para having heard that it counsels for the parties, let CTV call for. In the meantime, if the petitioner is arrested, he shall be released on publishing a bail bond of rupees 30,000 with 1 rupee CDP of life amount. Subject to the following conditions, he shall appear before the IO within 7 days from today. He shall not influence any person or witness or in hamper or tamper with any documents or move out of the jurisdiction of Mongoldoy PS without written permission of the IO. Matter be listed again on 23rd of August for CD.
1941.
Court 38 application of this FIR also will find page 14. Here in this case, the informant was having some matrimonial dispute with her husband, that is accused number 1. Therefore, due to that matrimonial dispute, this FIR was lost. And present petitioner, lordship, was the parental uncle of the main accused. And during investigation, lordship, the petitioners were interrogated by the investigating authority, lordship. That your lordship will find page 20. They were investigated and they were released on bail. And thereafter, when the charge sheet was submitted and summons was issued to me, and on receipt of summons, I filed one application before the learned session judge, because the case was a committal state. But the learned session judge rejected my prayer, without considering those aspects. That during investigation, police did not arrest me. And in this regard, I am just having one authority of honorable effect when it is saying, when during investigation, he was not arrested by the investigating agency, court normally should not remand him to custody. Kindly see that.
You show it before that competent court.
Yes, already my bail is rejected by learned session judge. That you are also.
You did not show the judgment. That is why it was rejected.
Even the learned application appear.
See,
Order paragraph 2 of the judgment, which I have placed. That is fact situation of state. And observation of the honorable court, you are watching in page 9 and paragraph 9 and.
this is subsequent to Siddharth
Watching.
and other judgments.
Paragraph 2, 5, 6 are facts similar to my case, when High Court also rejected his prayer. And therefore, paragraph 10, just make and see. More importantly, the applicants apprehends arrest not at the.
It flows in directing you to appear before, and if you file application, take note of the judgment and file. Then we'll have to call for the scan book. We can't, we'll have to look into the.
Because the issue is that
We'll have to look into the case. We'll have to satisfy ourselves.
because in the charge sheet also it is mentioned that I was on bail.
We'll have to satisfy ourselves.
In that case, I will be protected, because otherwise.
Other counsel with the parties, this anticipatory bail petition has been filed with the petitioner. Apprehending arrest in connection with. BRC case number 1490/2019 arising out of Counterfeit APS case number 250/2018 under section so. Learned counsel for the petitioner submits that the petitioner that the petitioner was all along cooperating with the investigations carried on by the police. Even in the charge sheet. That he had appeared before the IO and his statements recorded.
Statements were recorded
During the investigation. In the charge sheet which was filed. He was on bail.
Yes, they were on bail. They were not shown as absconded.
They were on bail and not shown as absconders. Also, however. When the matter was, when they appeared before the competent court, the bail and applied for bail, the same was rejected.
Case 30.
Same was rejected by order dated
35/2020.
3005/2023 by the Court of Additional Session Judge FTC Durham. Why was it rejected?
It was considered on merit as well as that only summons was issued.
On the ground that the apprehension expressed by the petitioner does not appear to be reasonable. Fair enough. Mr. Borahor appears for the APP appears for the state. And suffice that the matter be disposed of, directing the petitioner to appear before the court and apply for bail. Having heard learned counsels for the parties, since learned counsel for the petitioner has submitted that his prayer for bail has already been rejected and no effective order will be passed by the court. And he apprehends that no effective order will be passed by the competent court. He's approached his court. Let's scan copies of the LCR we called for in connection with PRC case number. So and so pending before additional session FTC. PRC 1490/2019
And SDG and Durham.
pending before SDG and Durham. Let the matter be listed on 18th July. With the next dates. Petitioner if arrested in connection with so and so case shall be released on furnishing the bail bond of rupees 50,000 to the satisfaction of the court of CDM.
CDM
Dorm. We are granting you the interim bail. List again on 18th. There is the registry call for the scanned copies of the LCR. On that day, we'll examine.
Item 40.
Yes.
My lord, update application, lords will find the complaint, my lord, at this 7 translated copy. Relevant person, my lord, at page 8, my lord, as many as 4 persons have been named in the case, my lord, as accused. I am not in the affair named in the affair, my lord. May I read out this statement, my lord? Harmful statement of the complaint is that the accused are worship bearer of Luxonagari Cow Panchayat and the complainant witnesses are residents under Luxonagari Cow Panchayat. The accused have been committing many corruptions in Luxonagari Cow Panchayat. For the year 2017-19 fund amount.
How many are arrested?
My lord, 1 and 2 has been arrested, my lord. I have included the forwarding report. I am not in the name, but I am also serving under the Panchayat, same Panchayat. And the police is also asking me to be present in the police station. Therefore, I am apprehending.
Gram Roshka Sevam.
I am
Round was there.
Gram
Heard learned counsels for the parties. This is a bit related petition by the petitioner apprehending arrest in connection with Moirabari DS case number 137 of 2023 under section 26. Stop learned counsel to the petitioner submits that he is employed as a
Ruzgar Chavo.
Rojgar Seva
Yes.
under
Under my lord, Luchanabari Cow Panchayat.
Luchanabari Cow Panchayat. Also, an FIR dated, where is the FIR?
My lord, at page 7.
That's a complaint.
It's a complaint. Usually
Complaint
for a
petition was filed, which was registered as CR 223 of 2023 by one MD Ilyas Rahman, making allegations of corruption against the members of the Luchanabari Gaon Panchayat and the officials employed by the Gaon Panchayat in respect of allotment of funds under the NREGA agricultural fund from Gunaibari PGGSY Road to Patuakata Bill Park, page number 8. Learned counsel for the petitioner submits that he is not named in the FIR, but he is employed as he is employed under the so-and-so Gaon Panchayat. And the police investigating officer has summoned him to the to the police station for investigation. In connection with the investigation on the case, he apprehends that he may be arrested. Therefore, is approached this court. Mr. Porahor submits that CDV call for the matter. Accordingly, let CD be called for in respect of so and so. Moirabari PS case number 137 of 2023. And in the meantime, if the petitioner is arrested, he shall be released on furnishing a bail bond of rupees 30,000 with one local security of like amount and subject to the following conditions. Shall appear within 7 days.
Right.
And the other condition will be listed on 28th of August for CD.
Deep learning.
28th.
I said July.
We want July. All right,
I was thinking, July.
28th July, all right,
14, 10 of August.
10th August, all right, 10th August.
1943.
438 application you have that kind of page 9 you have the matter during the checking you have a truck carrying 21 number of bull received by the police on this thereafter two drivers were also being arrested. I am not there. I am not. The problem is that I am the owner of the vehicle. The sections level again level in this case is 420, 379 and 411. These are not 411 not take to my case. Now police is arresting me is because I am the owner of the vehicle. I am not named in the entire
Section 11 of the provision of civil
I have no knowledge about the carrying of such cattle.
You are the owner. How?
6 only permitted.
Drivers were also being released on the 2 persons who were arrested.
Yes.
I will be protected. I will be any condition.
Yes. Partner counsels for the parties. This anticipated bail provision is filed by the provision of in connection with this sonat. Sarieli PSK is number 34 of 23 and the section 12 so that with section 13 was some cattle preservation act and section 11 of prohibition of cruelty to animals act. It is submitted that the petitioner is the owner of the truck clearing number AS25C9678, and the same was is a truck having a registration for to be used for commercial purposes. So the driver and another person of the truck, driver and the person, another person who, without the knowledge of the petitioner, have transported 21 numbers of bulls from Lokhimpur to Nagaon. Also, during a Naka checking, the truck was searched and the goods were recovered and the driver and the other person was arrested. And so subsequently, they were released on bail by order passed by coordinate benches of this court. Both of them released, or only one?
Both of them were released.
Counsel for the petitioner submits that he is not connected with the offences, but being the owner of the truck, the police is summoning him to the police station for the purposes of investigation, and he apprehends that he'll be arrested in connection with the same case. Mr. ABP Learned Counsel appears and submits the CDD call for. There are having heard learned counsels for the parties, let CDD call for. In the meantime, the petitioner is arrested in connection with insurance of case, he shall be released on furnishing a bail bond of ₹30,000 with one local civil like amount with the satisfaction of the arresting authority. It shall appear before the IO within 7 days. And the not and the other conditions. And will matter be fixed again on
21st August.
21st August for CD.
1944.
Yes.
For such a litigation, the case stays the account. Case stays the account. Fact of the case is there. Litigation.
Sorry.
Case can be. In this case, litigation is there when the informant is a police officer, element is that After getting information about selling the ticket here, they appeared to the drug number surgery market and found that 30-40 people had arrived on selling ticket. And when they appeared on Samuel, then the other accused person, they tried to erase him from the accused person. From the police personnel, that they the car is registered under state 147, 114, 353, 394, and 1314 doesn't give information. In paragraph 4, I listed the petitioner, you understood, in this stage, you understood. The informant arrived there, you understood, and one Shamor does not explain what, because they didn't take ticket. Then the informant should be by his pistol. And after hearing given cry, and also the petitioner arrived in that place, it is basically nearby the place of occurrence. And after that, this affair was lost. The petitioner is not involved in this really. City may be called for and property.
Irreversible time from the FIR, he is the person who is arranging the waiting for him. That is very much clear, madam. Only when they went to apprehend them, madam, thereafter there is couple and promotion to between the madam police officials and those persons, madam. And in the way, madam, one person is apprehended. The lawyer will find the below person, madam, how they try to resist the police personnel in their duties, madam.
Only to say there is the police.
For that matter, if one shot has to be fired at matter.
Who was injured? Petitioner was injured.
Petitioner is not injured.
Not when Shamor was selling ticket, petitioner was important. Put him here. Then the event crash started and other people arrived there. And after that, police left this place and lost Mr. Tata against the person. Petitioner is nearby the place of Bakari.
Go into their own hands.
Nothing other than there is no SR demand for there is no interior police staff, nothing there.
What do you do?
I make cultivator.
Then
My residence nearby the place of mechanical. I visited a Garrett Court is 4.
let us call for the CD. First, then we consider your interim protection.
No, you connected your integrity.
Let us see this. Let us call for the CD. Before you cooperate, let us examine the CD. This anticipatory bail is filed by the petitioner apprehending arrest in connection with. What is the case number? ES case number 232 of 2023 under section 12. Learned counsel for the petitioner submits that the FIR was lodged by one sub-inspector of the Golden PS making allegations that the accused persons, including the petitioner, are responsible for conducting illegal steel within quotes steel or for selling of illegal tickets. So when the police party arrived there was a commotion and the person selling the tickets sought to physically assault and restrain the police party, including the informant, from performing their duties. In the process, the shot had to be fired, because of which the injury was caused to the accused person number 1, whose petitioner is named as the accused number 4. The accused number 5. Mr. Goswami, Leonard APP submits that the petitioner is involved in the matter and therefore from a perusal of the FIR, it is seen that the petitioner is involved in the matter. Therefore, prayer for anticipatory bail may not be granted without perusal of the CD. Accordingly, let the CD be called for. Give us call for a short date.
Yes,
17?
17, this is the 20th, because 17 is the opening date. 17 or 19 months.
19. We'll examine and then pass. On 19. On which date, upon perusal of the CD, the prayer for grant of the interim prayer of the petitioner will be considered. All right?
Item 45.
Yes.
Hello, this is also post-target application. FIR also will find that case 9. My lord, allegation has been lodged by a financial company, alleging that they used to give loan, and on inquiry of the rule application found that different fund numbers are found in same name, and that is the basis of the allegation. Lord, you will find it para 5 of the FIR.
How are you involved?
My lord, I am no way involved, my lord,
Why are you
because
apprehending?
the accused persons who were arrested, they were arrested while they were visiting to a place and using my vehicle. I have a vehicle, the street, and that I used to give on hire. And that my lord, police is also required my statement. I will appear before the police, my lord.
How many accused persons arrested?
My lord, as many as 3 persons that arrested, also will find at least 40 name and address of the accused.
They are arrested from this car.
From my car. They took my vehicle on hire. That is my fault, man.
Your vehicle is registered for commercial purposes.
My lord, commercial purposes.
Where are the documents?
My lord, there are documents I have not furnished, my lord.
Then
My lord,
yes, some documents.
my lord, I will furnish my in the meantime, I will get.
No, in the meantime means the basis of your
My lord.
submission is that you are
My lord,
you're a person.
There is an order, my lord, of the order of the court below. My lord, rejecting my Zimma, allowing my Zimma petition regarding the car, my lord.
No, nobody disputes your car. But whether you are using the car for the purposes of
Yes,
commercial,
I may be,
on what basis?
my lord, I have.
You may have a personal vehicle, you may have gone together. There is a difference between,
That I can furnish, my lord, ideally, given some time, lord.
you get it,
My lord. My lord, lordship may also call for the case that I may be allowed to go on.
your interim prayer will be considered upon you satisfying the court that this vehicle was used for commercial purposes, and you have no role to play. They hired your vehicle.
My lord, my lord.
Huh?
Yes, sir.
When can you get it?
My lord, I will be giving some. My lord,
17.
Huh? My lord, on last 27th, my lord, on 11, my lord, I will give.
11.
This allegation court may not so it is on 17 because
Now you get it on 17.
My lord.
At the request of Mr. A.R. Siddhar, Learned Counsel to the petitioner, matter is listed on 17th, enabling 17th July, enabling him to furnish before the court necessary papers in respect of the vehicle that he owns, which he claims is used for commercial purposes. The documents we brought on record by way of an additional evidence. Please, from 17.
My lord, should we take out in the vacation?
13th.
My
13th. Mr. Goswami appears for the APP appears for the state.
Item 46.
46. Yes.
Hello, number 14. Regarding posting of some determined post.
Well, this allegation also earlier was against me, madam, which is the case number 21, for which I moved the jail, madam.
In your posting,
Madam, kindly see the madam date, madam. On 18/5/2023, CLA then I applied on the mistake. I was in jail, madam, up to 17/5, madam. Kindly some of the case number 23, madam. These are madam release order, madam. 17/5, I was in jail, madam. Thereafter, madam, I post something, madam, not like that, madam. The case number,
you are in which jail?
madam,
You are in which jail?
you are jail, madam, up to 17/5/2023. CLS on 18/5, madam. How can I tell you?
So 18/5, you are released on 17.
Yes, madam. Madam, what I uploaded, madam, kindly case number 25, madam. Can you see? This is the last affair, madam. It is environment, madam. Move forward now, for you, for madam. I out of anger, madam. I post this, madam. Out of anger, madam.
When did you post it?
Madam, case number 25, madam. Case number 25. June, madam.
On which date?
On 21st date, this is the date, madam. I screenshot from that case. This is a clear application. For which, madam, I again. There are two posts. Case number 26.
And who is the informant?
The informant is one of my ex-lover.
Who is the person against, who is the person who is referred in your post?
Well, some third party is there, madam. See, mentioned in the madam, FIR also, madam. One, Vivek or name, madam. These are third party.
No, some other person has mentioned it.
Madam, where, madam?
Page 24, 25, you are mentioning the name of somebody.
Yes, madam. This is my Vivek or name.
Huh?
Third party, madam. Vivek or name. It comes to our.
Yes, Mr. Goswami.
This is not the first offense for him. And the repeated offense, there he carries a content, it carries punishment more than the prescribed, because it is habitual manner. So let the CD with their manner.
I will communicate before the policeman. I will
1 year manner.
I will submit before the policeman. I am protected manner.
So what is there to submit? You have been inside on two matters. You have come out and you end the way.
And it is
For being manner.
Huh?
I will submit before the policeman.
and it is also a condition manner to appear
And
as
only 20 years for manner.
You may require some counseling by a proper counselor.
Yes, madam. I will do, madam, only for last month, madam.
they cannot give.
Last month might be given, madam. This madam, really false, madam. I myself post this, madam. What is happened, madam, is actually going on. Madam, this is my post, madam.
Which is your post?
This is madam, case number 25, 25 and 26, madam. This is the actual post. So. If madam, beyond this, madam, something is come in the city, madam, my will be cancelled, madam. This is my out of anger, madam, I have put this. After coming from
The FIR suggests that it is not only the writing, but it is also shared some obscene photos.
no. See,
That's why the FIR. So whether we cannot say whether only this is the post. Some other posts may also be there.
I think your apprehension is not played because even the police may be tired of arresting you. You will be in custody for twice.
Yes, madam.
So they must have released you.
Madam, only twice I have notified them, madam.
Therefore, they may not arrest you again.
No, madam, protection will be, I will. Update the reading, madam, right, if beyond this, madam.
What is there to happen? It is available in the social media. You have posted it. What more do you believe something?
Clarification, madam, what is happening in my past, madam. I'm last 23 years old, madam.
What do you do 23 years old? What have you been doing? Besides posting in the Facebook? What do you do?
He is a master.
What do you do? What do you do?
It's just complete graduation.
Graduation.
You cannot play with them and the guard.
Learned counsel for the parties is anticipatory bail petition has been filed with the petitioner apprehending arrest in connection with Jorhat PS case number 209 of 23 and section. So it is alleged by the petitioner that it is submitted by the learned counsel to the petitioner that the FIR is at page 16.
Yes. Page 9.
Page 14,
14 notes.
which will I see.
14.
Page 14.
Registered as PS case number 249. Jorhat PS case number 249
Yes, ma'am.
of 23 under sections 20. Learned counsel for the petitioner submits that there are certain allegations made in the FIR about the petitioner regarding certain posts made in the Facebook. So it is submitted that the same allegation is incorrect as the petitioner was in custody in connection with an earlier case and was released on bail only on 17/5/2023. Learned counsel for the petitioner submits that the allegations are false and the informants have misunderstood the post he has made in the social media, which is in the form of a clarification. Mr. Goswami Learned APP submits that the petitioner is a habitual offender and not to be granted the benefit of anticipatory bail. So, however, the CD may be called for. Where I having heard on counsels for the parties that CD be called for. When can you call for CD? 17th. 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 We'll not give you. We'll see the CD and then give you. You have been taken in custody in respect of the same offences, and you are coming out and again creating the mischief.
All this
We don't know.
beyond this time, my paying
Huh?
if beyond this, you must give it to some and my payment.
No. If this is it, then why are you apprehending the police will arrest? Nothing is there.
Police
Earlier,
non-believable offense of 67 days there. I was 50 for my. I was section of daily one. Therefore, I'm appealing. 57 days for a non-believable. 50 was non-believable. 500 daily was 290 for believable.
that CDB call for 17. Because the allegation is the same. Then when you have been taken into custody, you got bail. You may pray before this court anything, but the allegations against you, you do not deny that this was posted by you.
No, my post is page number 29. I am not denying. This section is
Correct. So let us examine the CD. List on 17. Upon perusal, the prayer for interim will be considered. Huh? Till then, no coercive action. On 17th. Till 17th. Don't post anything. Stay away from social media.
Item 47.
Yes. 47.
Regarding the EWA and detention. Yes, my lord, last petition.
Yes.
Lordship, on the last page only there, Lordship, here we have received instruction, Lordship, that it has not been finalized, my lordship. So at this stage, it is premature to, it's an apprehension, my lord.
No, how can it be? Do you deny this annexure, page 55?
Lordship, yes, that has not been notified yet, my lord. This is just a cabinet decision, it has not been finalized.
Where did you get it?
Lordship, this was.
Where did you get it? It's 55.
My lord, that is the notification actually posted in the social media.
Social media. Is there any official notification? Is there any official notification?
I have not received any of it.
All right, heard learned counsels for the parties, Mr. H. Chandiyal, learned standing counsel health. Submits that as per instructions received, the apprehension expressed by the petitioner is unfounded. And as on date, no decision has been taken to restrict EWS, 10% EWS quota for MBBS seats only for 6 medical colleges in Assam, namely Guwahati, Dibrugarh, Silchar, Jorhat, Tezpur and Borpeta, page number 55. He therefore prays for further time. Or we record and close it.
Lordship, there is an option, because the dates have not been finalized.
You're not getting the point. The question is whether 10% EWS is only for this or for all medical colleges.
Yes, that is the only question. That we have understood, Lordship.
So you have understood, but you have not given the
We have
reply.
not taken a decision on it, Lordship, because that is still under consideration. This is just a cabinet decision that was posted on the, because it has not been finalized on last 2 days, sir. My learned friend submitted before this one court, there is a decision that they are going to allow only 6 medical colleges. No, Lordship, on the basis of this document, because on the last date we did not obtain the instruction.
Mr. Cholia submits that no final decision has been arrived by the state cabinet as on date. Therefore, the apprehension expressed by the petitioner is unfounded. He, however, prays for further time. And accordingly, let the matter be listed again on 17th.
It is on 19th. 17th is the first.
19th. Anything wrong with the first day?
No, we are ready because the council. In the meantime, they may not fill up this 10% EWS seat to the others. Lordship, the dates have not been finalized. 13/6, the result was declared. Now it is already 1 month.
So in the meantime, what are your prayers?
My prayer is that EWS 10% reservation seat may not be filled up.
Why?
My lord, otherwise, if they will fill out in the 6 medical colleges, 12 medical colleges without to the general candidate.
That they can't do because the policy says you must make a corresponding increase.
Madam.
What is your grievance? Is your grievance that they are trying to fill it up without giving you are making a corresponding increase? Is that your grievance or?
My grievance is that, madam, last 2 days they have allocated 100 seats to the EWS committee. Now they are for the 67, but I am entitled for the 127. Total entitlement under EWS, and no decision has been taken regarding that. This is an apprehension by us. If they are submitting that they are ready to give the total 12 colleges, I don't have any grievance. Worship, we have not finalized anything. I cannot. They have to, my lord, because it is the dates have they have taken the dates have not been finalized. We have to amendment. Also that will come from the MFC bylaws, because we are not in a position when the dates. So on the basis of apprehension bylaws, the date, it is not necessary that their grievance will on 17th if we place it, there is enough dates for the counseling for them to participate also. That is why we are showing the urgency and we are listing it on 17th. Counseling won't end in 1 day.
No, before that, you have to take a decision.
Yes, Lordship, decision has not been taken, Lordship, dates have not been provided, so it's a long way to go, my Lordship. They are apprehending on this one.
16, 17 is not a long way, just 2 weeks away.
Yes, Lordship, that is what I'm saying, Lordship. We have not taken a decision. This is a mere apprehension on their part, my Lord. No decision has been taken, Lordship. I don't see, on the basis of this document, my Lord, which I have produced, my Lord, they are.
Mr. Jolia, learned counsel for the department submits that as on date, no decision has been taken by the competent authority in the state in respect of allocation of, in respect of restriction in, for allocating 10% EWS quota for MBBS seats only for 6 medical colleges as submitted by the learned counsel for the petitioner. In respect of medical colleges of Cohati, Digrugarh, Silchar, Jorhat, Tezpur and Borpeta. In view of such submissions, statements being made by the learned standing council, this court is of the view that in the event the state proceeds to proceeds to fill up the quotas for counseling, then the same shall be done in terms of the relevant notifications or
As per law, Lord.
And except
what is that page number
36.
in terms of the notice dated. This is a notice. What is that annexure 738? This is for dental.
It is a Assam Gazette for the reservation quota. As per the rules and regulation, my lord, we follow it.
That you are not with any specific instructions, what can we do?
Because Lordship, nothing has been finalized. Lordship, if I may suggest, Lordship may list the matter on 11th, my lords. If any decision is taken in the meantime, the petitioners can bring it up in court, my lords, because this is a mere apprehension at this moment. We are not disputing. Lordship may list it on 11th. We are showing it. We are saying that
No apprehension in, you are taking decisions as per what?
Lordship, here the dates have to be finalized by the medical committee.
Correct, dates will have to be finalized. After that, what?
After that, my lords, they'll provide us with a schedule, my lords. During that schedule, all the petition.
Who decides on the number of seats and the quotas? Who will decide?
That will be decided by the government, my lords.
We know it is the
And that
government.
decision has been not been taken.
Which government?
Lordship, the health department, my lord.
State.
Yes, my lords. And they have already, the National Medical Commission has already sent us the state list, my lords. Here now, we are only waiting for the schedule that will be provided by
So
the.
in the state list, what is the quota?
Lordship, that is what we have been assessing, Lordship.
Huh? You are not coming clean, Mr. Jolia.
Lordship, here we have not finalized. That is why we are not making a statement, my lords. If there is an urgency, my lords, if anyway, Lordship, that is why I am saying. Lordship,
Then we record your statement that till 17 the counseling will take place. You can't, you are not in a position to make that statement.
Lordship, here I am only suggesting, because I am not in the state because.
Once the counseling starts, do you expect students to go and appear in the counseling or come before court asking for orders?
No, Lordship, here, for that, the students don't need to come, Lordship, the lawyers are there. Lordship, all I am suggesting.
Mr. Jolia, don't make a mockery of the proceedings.
No, Lordship, or.
As a counsel, you are an officer of the court.
Lordship,
First,
I'm just
don't
suggesting.
make a
Lordship,
mockery.
I'm not,
If you don't have instructions, you take time, get concrete instructions and place it before the court.
Lordship, here,
That is the reason why on 30th you were given time and the matter was fixed today.
Lordship, here, the department said we are taking a call. Here, there is no urgency at the moment because Lordship, this is a application.
Mr. Choliha, learned standing counsel, in spite of being granted opportunity on the last date, 3006/2023, is not posted with specific instructions. The court has expressed displeasure. Let this matter be listed again on.
Lordship,
Give us a date.
Lordship may put it on vacation for Lordship.
You give us a date on which date you will have the instructions.
Lordship on 11th because.
On 11th, by
11th.
which date, if no instructions, concrete instructions of forthcoming, court may contemplate passing adequate order in the matter.
Lordship, I am saying here this is premature right now because Lordship, because we have not taken a decision. That is.
You are unable to explain that document at page 55.
Lordship,
Is it your document? You deny it.
this was posted on the social media. Lordship.
By whom? Do you
But
deny
it's a
it?
cabinet decision, madam.
Do you deny it?
No, we are not denying.
You are not denying it.
I am also saying.
There is a specific,
This
there
might
is a,
undergo modification, madam.
Mr. Cholia, your job as a counsel is to assist the court,
Yes, sir.
not to throw a smoke screen.
Lordship,
Don't try to do it.
Lordship.
If you do not have instructions, get your instructions, place it before the court.
Lordship.
We are giving you time.
Lordship, we are, it's here, the only problem which we are facing, Lordship, is we have not taken a decision, so on the basis of reservation, we are not, we will go as per law only, Lordship.
What is the law?
Lordship, the reservation that has.
What is the law
No,
in
Lordship,
respect of this? Tell us
the 10% reservation that is to be given, Lordship.
by whom and how many colleges?
Here, Lordship, here, that has not been finalized, Lordship. There are more than 6 colleges in this notification, it has been mentioned 6. Lordship,
How
what,
many colleges do you have?
Lordship, roughly, approximately around 12 to 13, Lordship.
So what will happen to the quota in respect of the other
Lordship,
colleges?
this is not final, that is the instruction that, Lordship, on the next day, I'll place more concrete, but this is not final, because this might.
Then don't say that there is, this petition is premature. You have no instructions as on date to say
Because we,
that this document is the document, is a decision, is based on the decision taken by the state.
this is a cabinet decision.
Okay, is a cabinet decision not final for you?
No, it might go, Lordship, because.
Are you
this is-
posted with instructions to say that the cabinet decision will get modified?
So that. Lordship, I was told that it might, this is not final, that is the only Lordship which I got.
You are a counsel. Kindly get specific instructions from your client or don't submit.
Lordship, 11, we will post it, we will come to, we will be able to.
11.
Lordship, we are showing urgency, we are not, we can post it on 6 also and we can update and there has to be a decision by us.
Are you doing the court a favor?
No, Lordship, we are assisting the court in any way.
Is this the manner of assisting a court? Is this the manner of assisting a court? You come to court without any instructions and then you fling your instructions saying that you are trying to assist the court. Be aware of what you are trying to do. You are an officer of the court. Behave like one. List on 11. We are fixing it on 11. Whatever submissions you have to make it on that day. In case of any other urgency, you know what steps you should take. We can't advise you on that.
248.
Yes, that he could not apply for that premier. What happened?
The Yola company has been removed from the list.
So you're not there.
How?
Is it an SC or ST? SC or ST? OBC.
Obviously,
By notification of has been.
but page 34, just able to page 34. Page 34.
$34 years.
Yeah. This is the salary ratio made of on 18/7/22.
And the notification was of 19 September 2020.
Now you can say that is valid up to 1 year. On the bottom left side. That means now I got my other marks also, I am just, I come the door of consideration and considering. Now they are saying that they have not. It's still valid on. Still today.
When was it removed?
Lordship 19 September 2020. This notification.
19 September.
Lordship,
Because after that,
after that.
your certificate was issued on July,
Yes.
27,
20.
it was removed on September 22.
Now system is accepting, that's why we have. done
System will not accept because it is no longer OBC. We will have to now think of,
In all the district, I don't know what the particular district.
you give him a copy of the notification. Share a copy of the notification. This is on the basis of a recommendation.
Lordship.
All the district is there, right?
Yeah, all the.
Only from Pekka district.
Kachari is not even named here.
Not named.
That has been removed. Other.
No.
Yeah.
They are removed.
Removed.
They are considered to be residents of these district, inhabitants of these districts.
Pekka district.
No,
Present British.
no, in the notification,
Right.
there are certain districts mentioned
Yes.
where this community, people belonging to this community are considered to be inhabitants.
Vishwar Loktengu, Shunpur and Nagaon, it is separate entity, civil of service. Achar is in the one district.
No. You kindly read the entire notification.
There are some report classes. To enlist the Johar community who are inhabitant of Pulagar so and so, is a separate entity. And remove the community from the list of communities.
So earlier they were under tea garden.
Yes, we are fully belong to tea garden. For Assam under MOBC at serial number 81, not 8.
So they are removed from tea garden. But they are still OBC.
But that's why this petition was not, my instruction was to that. Because of this notification, this application was not. My instruction was this.
That goal is still remain.
His ground is that he belongs to this community which is treated to be OBC. Your notification says that they were earlier treated to be tea garden.
Under
That has been MOBC. Now it has been removed and brought under OBC.
No.
Read it.
Who are inhabitants of the Goran as a separate entity and serial number 32 in the list of OBC of the sum and remove the community from the list of the communities of tea garden tribes under only under MOBC at serial number 81 was removed.
You're not reading the context. You read it slowly. Take time to read it. Your instructions.
That's why remove the community.
No. You read the entire. It's a small paragraph. You read it in its entirety.
No.
Really.
In question to the recommendation made by the Assam Record Classes Commission in continuation of the government notification number so the governor of Assam pleased to enlist Jura community who were inhabited of Pulagat, Jorhat, Shikshagar, Vishwanath, Lichbiyar, Sharadio, and Nagaon as a separate entity in serial number 32 in the list of OBC of Assam and remove the community from the list of communities of tea garden and ex-tea garden tribes of the Assam under MOBC at serial number 81. Now at the 34th page, okay, this is a certificate. This is to certify that so-and-so of village so the district so-and-so division Kashar Assam state belong to
MOBC. Okay.
Zoda community.
So you're not MOBC, you're OBC. One step ahead.
OBC my lord, and one step ahead, but even if OBC both elements, OBC. OBC. Suppose if I go out by law of MOBC,
You are trying to register yourself as what? MOBC.
it was the MOBC one.
So MOBC is removed.
You know,
So now you have to get a certificate for OBC.
so if OBC removed by the image still remain OBC by.
Provided you have the certificate.
This certificate, my lord.
This certificate is to
Page 33, Lord. Page 30.
33.
Yes. OBC.
You have two certificates.
Yes, this is also certificate of 29/11/21 it was issued. You are also to find that this is certified.
Now- No, you don't get.
Belongs to OBC.
See, Mr. Chaudhary, page 33, see the date of the certificate.
29/11/2021.
21, you claim to be an OBC. Then on the next page, 18/7/22, you claim to be MOBC. You can't be both OBC and MOBC.
What I understand about the OBC oblique MOBC.
Then why do you require two certificates? Then why did you apply for two certificates? If it was oblique, either or,
They can explain my lord, because what I belong to tea garden community, that's tea garden. That's tea garden community. I belong to it under subtype my lord.
that is what the notification says. This tea garden, earlier you were treated as MOBC. Earlier,
21 it says OBC. 21.
in the I'm referring to the notification. As per the notification, you were earlier MOBC at serial number 81. Now that has been deleted and you have been brought under serial number 12 of OBC. Now in the face of this subsequent certificate, is the earlier certificate cancelled?
It was valid for 1
It
year.
was valid for 1 year. So you have to apply for another one.
3 times my lord, I applied my lord. Earlier also I appeared once.
Do you have a valid certificate with you?
Which is the certificate?
Which one?
This 34.
34 is MOBC. Now you are treated as OBC. If the Mr. Counsel, what is the distinction between OBC and MOBC? They are treated now as OBC. Why do you keep creating hurdles for citizens? You accept this and treat it to be an OBC candidate. Again, he'll be relegated to applying for another certificate, which your officers will give him after 6 months.
Let me have the instruction on that note.
Yes, please do. But
If it is possible, then it is on reopening.
Council.
Not yet, not yet.
Only once count date is given, only 4-5 days out. That's.
then he has to apply, he has to get it.
If that is that, then I'll get only 4-5 days. I cannot apply, you know. Subject to that, I may be allowed to apply my.
You apply, nobody is stopping you from applying.
I cannot certificate my.
No, is there a bar for you to apply?
Yes.
Right.
Council, without that, I cannot apply for council.
Is there a bar for you to know what do you want to apply for?
I online application. Online is not accepting. It's not manual one, online application.
See, the problem is nobody in the government wants to take a decision. Especially in the government offices. You have a certificate of OBC, which was valid for 1 year. Then you applied for MOBC. which is now valid for 1 year, which will expire on 18/7. Nobody in the government department will take a decision to say that yes, OBC, MOBC certificate is good enough for you to apply under OBC. Why? Because no notification, no rules. Unless we direct.
I don't mind to point out there, but if they allow to subject, even the manual they can allow from medical. If I do not come, that.
Manual you cannot. The entire system is online. Even your counseling will be online. Marks you get are online.
Just a provision, there is problem.
Then you have to apply online.
But it also that to me.
Yes,
Looking at the inspection whether it can be treated, otherwise.
not only treated, he must be in a position to apply online because that is your style. Unless you want to accept offline.
I will take the instruction number.
When can you get the instructions?
On 11th of
11th. When is the next date? Next vacation code? You get it by 6th. Why do you want to keep him hanging? He's a student, he wants to apply. You are creating hurdles upon hurdles. Mr. S.S. Roy, learned governor today, submits that he will obtain instructions as to whether the certificate available at Annexure 9 page 34, certifying that the petitioner belongs to MOBC, JOLH, Jolha community. Can be used to consider the case of the petitioner under OBC as the same community with effect from 19 September 2022. He is treated as is included at serial number 32 in the list of OBCs in Assam and removed from the list of communities of tea garden and ex-tea garden tribes of Assam under MOBC at serial number 81. Also, let the matter be listed again on 6th, on which date the Government Council for the department will obtain specific instructions in the matter. So Mr. Chaudhary, assisted by Mr. Chaudhary, appears for the petitions. 6, 7. 6, 7, yes, 6, 7.
Main hearing BA, item number 50.
And population. None appears. Last one.
Item 51.
Yes.
Instead of 27, for a medical report of the.
2007.
You can see the wife of the petitioner is not well. It is one to look after. She is having some critical gynecological issue. It's required to be taken outside. That's why I made a mention. And also may kindly see the matter was first.
Where is your FIR?
Also may kindly see the matter was first listed on 25/5/23. And along with the case diary, medical report and 164 statement was all follows. The case diary and 164 report was produced by the before, but medical report was again directed to be sent by the IO on 13/6. Then they again it was listed on 21/6, then 28/6. Will also be on the only because of the lapse of the part of the investigating officer not sending the medical report. The petitioner is lingering within the bar. He is already 59 days within the bar. The lapse on the part of the investigating officer.
Yes.
Medical report or more descriptive what I have found. And we have also mother telephone, telephonically also protected investigative hospital. And forwarded came one of the medical report, but it was not forwarded. We have not received it.
The petitioner is already suspended from his job. The wife is also running some critical issues. We have certain old documents, medical documents. And in the FIR also, the allegation made by the victim informing us, it is of the omnibus type of offense. He is alleging everyone, included, she has included her father also. And the allegation starts from the year 2017, October 2017, and it goes up to 2022. And this is laws in the year 2023.
The allegations are serious.
Allegations are serious. I'm not from very close. I'm
Yeah.
considering the length of detention laws. When the
Length of detention is still some time to go.
the condition of the wife is not so well. That's why I'm submitting on instruction. So I'm having some medical documents of the month of April 2023.
And without medical report in a matter of this nature,
Only because of
the statement of the informant.
that has been produced on 13th.
Nothing is indicated here.
There are another delegation.
Do you have the CD?
My lord.
Statement is available here. Let us have a look. What is the name of the petitioner?
Because it will.
What is the state of investigation? There are allegations against so many other persons.
There are so many other particular.
And then there is, from where are you getting the medical reports? There is a reference that she was undergoing treatment in Tezpur also. Then
It takes much time. And as per my instruction, also the other
Why have you not been able to procure? That's the question. Who is at fault? Who is at fault? The IO.
Whether matter of the medical report collected or not, if it is collected, not the IO is found to be found to matter forwarded, the case there is. There is no reflection in the case there.
But the other accused who have been arrested in section of law, one of the accused was given a by this time they have been doing something. It's 59 days get about 35%. On any condition.
You call for the medical. You want to see. Or we call the IO.
The last one will be given to others, but my will ask the
In spite of several opportunities granted, the medical report, one medical report as called for is not available in the case diary. Statements on the 164 CRPC made by the victim is available on report, is available in the case diary. As a matter of purely for the interest of justice, is a matter of last opportunity. And then APP is permitted time to call for the medical report, failing which consequential orders may be passed by this court. This on 11th.
Can it be after? Can be secured the concept?
It cannot be, no, WhatsApp. How do you expect the court to? There is a report on WhatsApp.
Let it be on 11th.
Let it be on 11th.
It can be transferred to electronic or via email.
Like anything could have been done, but not done. Don't expect things which are not happening. It would be nice to have all information ready on the first day itself. And you are quite right. Electronic medium should be used by the state now. Do you encourage or discourage your clients to use it? Do you at least encourage your clients to use the mode of electronic transfer of data?
Sometimes I say no also not clear. Sometimes what I cannot do, the report call for because immediately guided for, but only would for then we might not be actually not indicating of the contract to provide it without one thousand. It's 2 hours. If you don't minor, the utmost.
All right, list on 11th for production of the medical report. Mr. D. Das appears for the petition, who submits the petitioner has been in custody since for 59 days. 59 days. List on 11.
Item 52.
That's it, submitted.
There is 3 persons, one is father and 2 are from one is minority, is income builder. Take 9. Second by the judgment of mercy. Ramachandra is just concerned about the parking place of own houses, which is Bhutai. Meeting of the house of his medicine and these are money because my father is very also informed or informed. There's a music part not that today I am my father by chance informed also.
No, then we'll have to call for the scan copy. You want, or we close it, you approach the court, competent court.
Because that was submitted before.
There are allegations, previous allegations, serious allegations against you. Election.
Go into my house and committed illegal activities with my minor daughter.
What is the status of this matter?
First, Sasi submitted on 30th of May, subsequently submitted before the court delivery. But nothing will come, only Sasi will come.
No, in the subsequent, in the other FIR, filed on the same day.
That is 45. It is better for him to approach the court because Sasi will be available. Again, call Malab, that will come Malab, then.
It is for him, we are giving him, yes. Huh? Hmm? Then we'll have to call for sale. Let us find out. Along with the CD, etc. What else? On what basis do you want us to grant you bail? Tell me. How do we satisfy ourselves?
After committing the
In order to consider your prayer, what materials are available before this court, tell us, other than your petition and the submission? Heard learned counsel for the parties, call for a scan copy of the LCR in connection with Caroni PS case number 44 of 2023 under section so and so from the court of CGM, no, special, not CGM. It's a POXO matter, isn't it? No. CGM, not be CGM. From the competent court by the registry. List upon receipt of the scan copy is called for. 18 July.
$53.
I'm for 6 days behind the bar. I take you up to page 9, that is the experiment.
Why did you pray for adjournment on the last day? No, it says at the request of the council for applicant.
That's why we have adjourned. There was no CD.
CD available.
But I take you up to page 10 of the affair. There are 40 containers containing the suspected narcotic drug, heroin. Total content is 52.84 grams, including of the plastic covering. The honorable court directed to inform the court what is the total actual quantity excluding the container. Whether that has come or not.
Yes, as far as actual suspected drugs weight is 3.84 grams. 3.84 grams.
It is small quantity, minus.
And now, if you as far as the equipment, they are that we believe this business and I mean, overhead or without trust. That is peddler. And now,
the consumer balance.
consumer and peddler. They go high road, and now.
Consumption is also illegal.
That is true. And effective spending.
While it has come that it is on 3.2, it is small quantity. Maximum detention period is 50 days, man.
Yes.
And but I'm 46 days, I'm already behind the part. So your option may consider my prayer, man.
46 days.
46 days.
Your 60 days will come on 17th.
Well, FSL is not different because I am admitting that it is illegal. Then I am admitting it is illegal because I am a consumer.
You have two options, either to argue on merit or wait for the.
Well, you also can consider 46 days behind the bar, man. I am experienced, I am punished enough, I will not do it.
You are suffering, you are suffering from deprivation.
But I under any condition, kindly let me go on. But I have punished enough that this is the wrong path I have chosen my. Let me give an opportunity to come to right track.
Yes, what do you say?
From my side, they will.
Even if the FSL comes, it will come as a hearing matter.
They will continue and they will.
I will not continue. Give me an opportunity. Give me an opportunity to be rectified in my life.
That opportunity is being provided to you now.
No, inside my growth. Still, not help me to correct my life, man. Your Lordship has today in a one case that requires the counseling. This is the case where counseling is very paramount requirement for the rectification.
You wait for some more days. Let us see. Let us see.
By detaining me, I think it will not improve.
The age, your age
Yes.
does not give us confidence that some amount of counseling will help you to go back
I
to
tell
where
you,
you were
Dr. I
earlier.
think that I definitely have done.
Hmm?
Because there are hardcore criminals. So by counseling, they come to the right sector.
So you can get counseling after you get out after a couple of weeks.
But at 46 days, I have already punished enough.
You
I'm
wait
not
for some more
realizing
days.
the
Let the matter be listed again on. Hmm?
The lady of religion, my lord.
11th. All right, 11th. As requested by learned counsel for the parties. Meanwhile, FSL report equal 40 and produce before the court on 11th. CD we retain, but for FSL you need to send the CD. Do you need to send the CD?
No,
CD receipt be retained. Next on 11th.
54, item 54.
Which was behind for 40 days. And finally, this 17.
Page number FIR.
Number is 17. Myself, Modi Singh.
yeah, I am just because I'm supporting the matter. He if some other person doing the business of taking vehicle from some person and giving to person of Nagaland. And this person taking the vehicle of the informant given the person and on the he got 1,50,000. This application on it. Subsequently, that vehicle was seized by the police from Nagaland, and the informant got demanded. That the vehicle was given to the owner, the informant, and demanded. The vehicle recovered. But this petitioner,
I think the one was the Rahul, the Brage has taken.
Yeah, why were you arrested? Why are you named here?
no, because
I have tried to settle this worship, in the affair itself.
39 days.
And also to,
What is your name?
my name is Novi Singh.
Where are you referred in the FIR?
Worship, paragraph, worship, second paragraph.
You have to sit in our informant.
Worship, vehicle has been recovered. It has been handed over to the complaint also. Today it was, next week of, worship, I have not, returned, I have just given date and date after date. And the major reason again was to Rahul Dikage and after 1 month this happened.
Yes, CD.
CD available, CD available is what, in the chapter number G, with some other person, he gave the, Northwest, Tata Dimapur. And, they got 395 rupees, that they all group. This prisoner got out of that 395 rupees, 1,50,000. Subsequently, police recovered the vehicles and given remark to the original owner.
Now, what is the stage of investigation?
All the persons now there is a group malak. This group is being structured with this malak, taking vehicle on rent and given to mortgage and other thing personal money to the and luckily it is getting recovered. Length of detention as the vehicle recovered.
Hard learned counsels for the parties. This bail petition is filed by the petitioner. So, who was arrested on 26/05/2023. And he has been in custody since then. Posted an FIR dated the date 6/5/2023 was lodged by the informant, one Sajol Saha, alleging that the FIR named accused persons had taken his vehicle and it is suspected, as the vehicle has not been returned back, in spite of assurances, the same has been sold off to some other person. Although there are no specific allegations against the petitioner, there is a reference that the petitioner is alleged to be the cousin of the prime accused and had assured the delivery of the vehicle to the informant. Other counsel for the petitioner submits that he is no way connected with the offences against. He was merely trying to sort out the issue between the informant and the accused person's name, other accused person's name there. However, during the course of investigation, the petitioner was arrested on so and so date and he's been in custody since then. Where are Mr. Courtroom learned counsel submits that the CD code for has been received and the vehicle in the meantime has been recovered. And during the course of the investigation, it was found that The vehicle was sold for an amount of rupees 3,95,000 and a part of which
Even mortgage. Not so.
not sold, mortgage.
Mortgage.
It was mortgaged
The person of Dimapur.
to a person of Dimapur for an amount of rupees 3,95,000. And a part of the amount was shared with the present petitioner. But I having heard learned counsels from the parties, this court is of the view that the vehicle having been recovered and handed over to the informant,
Dimapur.
considering the period of detention and the progressive investigations carried out of this court, is of the view that further custodial detention of the petitioner is not necessary. Petitioner be directed to be released on bail upon furnishing a bail bond of rupees 40,000 to the satisfaction of CDM Dimahasau of loan. Petitioner will continue to appear and cooperate with the investigation, appear before the IU on each and every day as required, and he should not move out of the jurisdiction of the district of Dimahasau without written permission. Bail petition is accordingly allowed and disposed of. CD returned.
Item 55,
If you have figure in that legal, what is my good thing? And it's about 7,550, place 59 days.
89 days,
59 days, sir. 59 days.
59 days. What is the FIR? Where is the FIR?
The price is page here now.
Parmis Subari.
But I am the driver and given man. And is driver and another. Please send it on 2 days.
CD not received.
Not written.
You wait for CD. Learned APP submits that CD call for has not been received. List again on
Today, 58 days. On 11.
on 11th. For CD. What is the period of detention? Huh?
This 19 is something like 4:1. The 4:30 is registered giving installed for 42. It is not applicable in my judgment. I have not given him.
Yeah, list on 11.
item 57,
It's even to be not.
CD and 164. Mistake. Learned APP submits CD along with 164 statement and medical. It's not been received. Therefore, replace for further time. List on 18. 18. 18. 18 you like.
item 60,
Can you 11 minor?
CD will be necessary. Third learned concepts for the parties. Mr. Eddie. For learned APP submits that CD call for has not been received. List on 18.
Can you 11 minor?
No, 18. On 18.
item 61,
CD retained, page number,
Page 10 is the matter of the.
page 10.
Page 10. Petitioner five taking particular name in that record. And then it's maybe that record, this then.
Yes.
That's what we said that in reference to the statute about. Today on 25% can pay about 20 and 1% per ticket in front of I convey in charge of. As an ask share take and stuff arrive at the residence of Mama. One number of mobile phone and number circle has been seen in presence of public presence and figured that the one for information and they encourage that accused primarily and are also involved in the process and accordingly we added at the resident of Mama primarily and charge the house in the one bank passbook and motorcycle and has been seen. And after we went to the resident of media, after conducting search, we recovered taking housing book, used for examining as and a passport and accordingly celebration in presence of and the security has been needed. Upon further introduction, the accused Muhammad Islam of
Why was the matter deferred to in the earlier dates?
earlier date matter CD was not available.
CD is available, it was returned, retained.
It was matter take with another case. On the last of the matter, CD was not with this item matter.
Another court,
It
okay.
is matter in another court matter, therefore I made it for.
Yes, what is there?
Petitioner is the paragraph one of the main. How it is recovered and seen.
No, what allegations, what materials are you saying?
Only he is supporting and doing this business. Fact and blocking and one of the factors, lots of business effects are going on. Selling out perfect gold boats.
No, that we know, but what is the material revealed in the CD pursuant to investigation insofar as the petitioner is concerned?
It is very confirmed, he is helping them.
Helping how?
Helping how to where
What about the status of the main prime accused? Who are in custody?
Abedal.
Abedal.
Cover of the main petitioner.
What about Tamir Ali and Amir Ali?
You are still in custody.
Out of similar incident, madam, many cases have been start, madam, in some cases, many persons have been arrested, madam, and in those cases, madam, the court has granted bail, madam, and have been
In connection arising out of the same case?
not same case, madam, but similar case, connecting to madam, I think over 64. Many persons have been arrested, they have exposed, and already granted.
I will 96 terminations. I think that at this stage of investigation, it's the part of it. They can find that for investigation.
I mean, the program,
Yes.
Only thing is that many more the person is yet to be arrested for taking record providing on that area. That is the investigation of it. Within and buying the
Are the counsels for the parties? This bail application has been filed with the petitioner. So and so was arrested in connection with Lalu PS case number 97 of 2023 under sections so and so. The petitioner was arrested on 23/5 of 2023. And since then he has been arrested. Since then he has been in custody. And FIR dated
this
20/05/2023 was lodged by the informant who was an SI under the Lalu police station. Post office was alleged that fake currency notes of about rupees 46,000 have been, and one mobile phone along with a motorcycle has been seized from the accused persons named therein. During the course of investigation, the present petitioner has been arrested. Learned counsel for the petitioner submits that he is arrested as he is the brother of the prime accused named in the FIR. Anything recovered from him?
From anything. And then it is no.
No recovery has been made from the petitioner. So, however, during the course of investigation, this court called for the CD, Mr. Mr. Goswami, DPP, submits that during the course of investigation, it is found that the petitioner has assisted the prime accused in his dealings notes. So, however, no recovery of any fake Indian currency or any other objectionable material has been recovered from the petition. Also, the matter is under investigation, and some more persons are involved in the as some more persons are involved in the offences alleged. And having heard learned counsels for the parties, this court is of the view that considering the period undergone and considering the extent of investigation carried on by the investigation or agency, this court is of the view that the prayer for this bail can be granted to the petitioner. Petitioner is accordingly directed to be enlarged on bail upon furnishing a bail bond of rupees 40,000 with 2 local securities of like amount. To the satisfaction of CJM and subject to the following conditions. The petitioner will continue to appear before the IU as and when required, and he shall not move out of the jurisdiction of the Lalu police station without written permission of the IU. Will continue to appear before the IU till completion. Bail petition is accordingly allowed district of CD greater that are lying awaiting the hearing councils and pension of the CD. No materials are seen that the release of the petitioner at this stage will affect the investigation carried on. Yes.
Item 62.
Scan copy.
Here are some messages on 28 on comparing the fever and minor. I got the charge was 30 days 5 minus 140 days everyone again matter. I was near page 16 obligation for each season matter. I have been 7 days everyone together. Next to page 16.
PVC pipe.
126 of 4
Scan copy. Yes, anything to submit? Heard learned counsels to the parties. This main petition has been filed by the petitioner. But we call for a scan copy. It is not come. We don't know, so we can keep it on the next available date.
Madam, I have any still for the bit.
No, you have done everything, but there is an order of this court
Yes, my lord.
that the scan copy be called for.
Can we come, six, my lord.
6 people will not come.
At the metro.
6 people will not come. Today is 4. 6 will not come. I mean. This court by order dated 28/6/2023 had called for the scan copy in case that because same has not been received as on date. However, considering the period of detention undergone. Let this scan copy read for by the registry of this court. The matter be fixed again on. Let us have it on reopening. On 18 July. The registry to call for the scan copy is that. 18 July.
1963.
It is here.
Kindly see the 164 step.
It has been given during the course of the day. So. Where is the FIR?
Lordship, FIR will be page 13 in my petition.
What is the age of the girl? And who is the petitioner? Person who was stated to have eloped.
Yes.
Taken away the girl. What is his age?
I am in 20 years.
Hmm?
I am in 20 years. Petitioner. I am also underage.
You're also underage.
So far marriage part is completed.
Yes.
Now, my lord, basically the allegation was that my lord,
Hmm.
the informant has alleged that I had lured a minor girl with an intention to marry. So 161, 164 minor closing the family carries it better any methods regarding the kidnapping or during whatever manner there against the and my lord, basically, lordship is aware, my lord, this offense is 366. Basic ingredient normally, my lord, the two conditions basically require, my lord. That firstly, my lord, my intention has to marry against the will of a woman, my lord. Secondly, my lord, I have an intention that or knowledge that speaking woman is likely to, my lord, due to ethical enforcement. Basically, these two ingredients must be clear, my lord. So 164 will be speak about whatever is there, my lord. And I made typically I've made a statement, my lord, in my petition, my lord, para 5, my lord. Wherein FDS, my lord. Last FDS.
Yes, Mr. APP, you can go through this. Forty-seven. Please, 47. Our learned counsels for the parties, the bail application is filed by the petitioner. Praying for bail. In connection with. FIR dated 7/5. In connection with Howrah Ghat PS case number 2021. 21 of 23 under section 366 IPC. Post of petitioner was arrested on 7/5/2023 and since then he's been in custody. Learned counsel for the petitioner submits that an FIR dated 7/5/2023 was lodged by his father, lodged by the informant, one Dilip Malik. No, was lodged by the informant, one Dilip Malik, who is the Gaambura of the village concerned. Also, in the said FIR, it was alleged that a resident of his village, one Sri Paul Mazumdar's daughter, who is aged about 14 years, had eloped with some person. Subsequently, he got, the informant received information that the petitioner had taken away the daughter. Also, being the Gaambura, and considering the fact that the girl is a minor and has not attained majority, the FIR was lodged before the concern of the station. Stop. Upon perusal of the upon initiation of the investigation by the IU, the petitioner was arrested and he has been in custody since then. Stop. This court, by order dated 28/6/2023 at call for. There are the upon investigation, the charge sheet in the matter has been filed by the charge sheet number 21 of 2023 dated 29/5/2023. Before in PRC case number 80 of 23 from the court of additional CJL before Abiyango also. This court by earlier order dated 28/6/2023 at call for the scan copy. Also, the scan copy is called for has been received. Also, from the scan copy of the LCR, it is seen that the victim girl in a 164 statement did not implicate the petition of the allegations made in the FIR. Also, rather, she stated that she was constantly physically assaulted by her parents, her mother and her elder brother. And out of sheer frustration, she had called the petitioner and requested him to take her away. Also, the same issue with the statements of the victim girl as seen from the statements on the 164 CRPC is also reflected in the report given by the council, which is a part of the LCR scan copy of which has been called for by the school. Fair. And it comes in for the petitioner as well as the learned APP has been heard. And on hearing the learned counsels for the petitioner, for the parties and upon the result of the LCR is called for, this court is of the view that the prayer of the petitioner for grant of bail can be granted. So the petitioner is directed to be enlarged on bail upon furnishing a bail bond of ₹30,000. The satisfaction of CJM default are being full stop.
Today I been informed that case transfer to
Special court.
session, district and session that Calcutta. The case is registered as.
Is it as a POXO case?
No, my lord. Since offensive trial of session court.
But I think it will still be CJM,
But let court below.
competent court.
Yes,
Competent court. Subject to the satisfaction of the competent court. Whereas the petitioner will continue to appear before the court on each and every day and shall not move out of the jurisdiction of the court of so and so without specific permission granted by the court. Bail petition is accordingly disposed, allowed and disposed of.
I'm a black man.
Yes. We are at the end of the day. Other matters left over?
And we are looking in item number 9.
We are committed to take that unlisted which we have given permission. Yes. The rest of the matters.
Should be 1 meter. Only it will take 1 minute time.
Even as well.
Item number.
Yes. I have informed there are 10 matters. We'll take it up. Yes.
Item 64.
Subject to, of course, there being no objection from the public prosecutors. Yes.
Item number 60. Out of the same pattern.
Yes.
Therefore, before I will enter the on 28 and all were granted, including the apparent equity. Only person has been
CD received. You go through the orders and tell us. You go through the orders. While you examine, we'll go to the next matter. You examine it, yes.
Item 65. Along with 9.
Like the same. Gold like
Mhm.
both in this connection notice, I have in item number 9, I have submitted the copy of the order notice on the this apply for the bill notice, they have been released on bail. My one item number 9.
Item number 9.
Yes, I have submitted item number 9.
Ah,
I am also not FIR in it.
what is the name of, what is the case number?
B2 case number 96.
Yes, Mr. Goswami.
Number 1, Mahalo is fine. The main file is good. No, I understand it. Then as far as CD, I'm going to look it. And that's what needs to be done. 12 PR should be done. And other than just that place of the recorded. Only FSR report of the fact will get to be received.
What is the FIR?
FIR is 30 case number 13A.
Who are the persons named in the FIR?
The person naming the FIR is Mohammed Zakir Hussain.
No, let us come one by one. Alaluddin.
Yes, sir. These are the suspected persons, Alaluddin,
Hmm.
and thereafter Zahirul Islam. And the third one is Muhammad Mizanur Rahman, and fourth one is Abdul Razak, and fifth one is Abu Said. He has been, I think, released on bail. And the other suspected accused, you will find in Muhammad Zakir Hussain.
So Alaluddin and Abu Said released on bail.
Yes,
Zakir Hussain released on bail.
yes, sir. Only person who applied for the case of only accused.
Yes.
Police third public doing investigation is number one house. The recovered simple half equal golden color article having a board shape weighing 1.10 the involvement is here of it. Their statement is here. Their evidence of it. Other witnesses are taking another particular person.
And who is in the other matter? Baharul.
Item number 9 is item number 65 from neither nothing has been recovered. And
from
from Baharul Islam, though it has been stated that one is a golden color is something is recovered, but it is not recovered from the premises of the Baharul Islam.
where was it recovered from?
Nothing.
Where was it recovered from?
It was recovered from the bedside of the Baharul Islam house, but not within
The meaning of backside. Not from.
the.
Yes, you want to go through these orders? Hard learned counsels for the parties. This bail application has been filed by the petitioners. Item 9 and item 65. Having filed praying for bail as they were arrested as they are arrested. One item 9 is one person and 65 is two persons. Three persons. This petitioner before this court has prayed for bail as he is arrested in connection with the Puria PS case number 96 of 2023 under sections. An FIR dated 24/4/23 was lodged by whom? Lodged by whom?
And not by one SI.
Lodged by the informant who is an SI under the Puria police station. Also because alleged that where is the name of the petitioner in the FIR?
FIR in the FIR, his name is not listed. He is not named it.
The petitioner
Only for it is
in
not.
item 9 is not named in the FIR. However, during the course of the investigation, it is submitted that a fake gold like counterfeit statue of Jesus Christ and a fake gold boat was recovered from the premises of the petitioner. During the investigation, several other persons have been arrested, and the it is submitted that this court by court and benches of this court has already released the other co-accused who were arrested on bail. CD is available. The CD is available in connection with BA number 2334 2023. Upon hearing the learned counsels for the parties and upon the perusal of the CD and also the orders passed by coordinate benches, this court will be that considering the investigations carried on by the investigating authority, the petitioner, who's been in detention since 14/6/2023. What do you say regarding the orders passed?
And other bail petition also include of like, I have only connected this with what Thomas or conflict no recovery was they are located.
No recovery of fake Indian currency has been made from the petitioner also. Considering the orders passed by coordinate benches in order to maintain guarantee, this court is intervening that prayer for bail can be granted by this as prayed for by the petition. No materials are noticed from the CD to suggest that release of the petitioner on bail will hamper the progress of investigation of the case carried on. Accordingly, the bail petition is allowed. The petitioner is likely to be released on furnishing a bail bond of rupees 50,000 with one local CVT of life amount to the satisfaction of CDM. Looking
Yes.
petitioner will continue to cooperate with the IO and appear on each and every day as required till completion of the investigation. And he shall not move out of the jurisdiction of Courtroom police station without leave of the without written permission. What was recovered from petitioners in 2334? Baharul Islam, Guljar Hussain, Ajizul Haq.
From the poverty report from Adizul Haq and the Guljar Hussain, nothing has been recovered from them. As per the poverty report. Golden color articles.
What article?
After the golden color article.
The allegation is what? Fake currency.
Yes, sir.
So what? How much of fake currency has been recovered? Not recovered. Fake gold. What is fake gold? Is it gold or not gold? Not gold. So
from Guljar Hussain and Adizul Haq, something has been recovered.
and from the petitioner one,
Petitioner, only from the petitioner number one, one piece of golden color, something has been recovered, but it is not nothing.
golden color what?
One piece
What is the name of the petitioner one? Baharul.
of So really, earlier reason what we petition, I think is for the same kind of also consideration of that.
No recoveries made from the petitioners. And seven rounds released and furnishing bail bond of 40,000 each with one local security of like. Huh?
Again.
Standing 64.
Yes. What do you say?
Actually, the same characters. We were not that way.
When was he arrested?
21 5 21 5 4 days.
Where is the FIR?
As far as the press present.
What is the name of the petitioner?
Abdul Kalam.
Abdul Kalam. But this was recovered from your house.
It was alleged to be recovered.
Huh?
It was alleged to be recovered.
From the other petitioners, it was not recovered. All are involved is a different issue. But in your petition, you're the prime accused. What is there in the FIR? CD?
Otherwise, there is material against the already been filed the
What? Positive what?
Regarding the
Fake currency.
currency is all fake currency. And gold is one of the fake gold.
What is this fake gold?
Fake gold may not, it is not gold. It is some.
It is being sold as gold.
Yes, so my lord, it was my lord, sell as a gold. And my lord, investigator is pending, my lord, there are some other items from my yet to be arrested.
Only petitioners, only one.
There might not only one,
You wait for some time. Your recovery is made from your possession. Seventeen. Let the matter be listed on 17th and on 18th. CD be retained in the next day. Yes.
Bail hearing, item number 66.
Effective was control. So immediate was 18, let it come upon 18.
18. All right. 18. Right. CD along with FSL be retained.
Item 68.
Eighteenth. Have you done 18? CD receipt.
Yes.
What is there in the FIR? In the 164.
161 the indicator, I mean, what the case of possible. Is maybe. Is was been setting the motion against the present accused person in the FIR. Nothing is specifically mentioned.
Oh, forget the FIR. What is there in the FIR? It is part of the investigation.
Yes.
FIR is an FIR.
16 years ago.
It is not filed by the IO.
FIR is 164.
really implicated, but it is related to that. Because marking specifically adheres to the FIR. But no, we have against the FIR. We are not putting. Medical, after 3 days, there is no.
Why after 3 days?
Hello?
Why after 3 days?
Well, you are recovered after 1 day, it's the second to go on, it's subsequently recovered, and yeah. You don't know 75, medical. Yes, 16.
Grave allegations.
If the medical report is in our favor, then I would like to appreciate my.
Medical is supporting, but there is a statement made under 164.
And whatever it may be, this is the subject matter of trial in the matter is charge sheeted. But at this stage, my lord, I would like to run investigation by substantiating my case.
You join, we'll facilitate your joining by dismissing your petition.
No, if you not should dismiss, then I may be expect from.
You wanted to join, you have to join because the allegations are very serious.
If the medical report, supports or against, prosecution.
Medical report isn't the only evidence to decide whether you are involved, not involved. There are statements.
With regard to, allegations made in this case, medical report is the, one of the relevant material for.
Counsel, we are not convinced. We can give you one more opportunity to convince us on some other date if you want. As on date, we are not.
Eight of the victim is yet to be affected.
Hmm?
The school certificate available, just picking and
Someone, fails in, because when the age is 60, then there is 2 years grace period may be considered. Matter of.
Do you want the matter to be taken up on some other date?
Yes.
List on 17th. CD received the retail. At the request of the council for the petition.
Item number 70.
Scan copy. Scan copy, I think. Scan copy has not come. 17, we can get it on 17. List on 17, as the scan copy is directed to be requisition from the court of CJM Kamrup Metro has not been received as an objection. List on 17.
Item 71.
Yes. Page 10.
Yeah. Okay, FIR was lodged by the one sub-inspector. Before the officer in charge of the cycle of the.
Is there a ban?
This related to illegal action, this is a, and second, other important thing is that the person who carried the mother, it would be the track, one from I was arrested. The document was funded by this party, this executive which was for private. And all the documents he has given notice, it was all fake. I am not that person. I own the full flowing pilot. Specifically made the statement as paragraph 5 of the. I own the Dhaba, the vehicle admittedly houses there for full pilot, then they informed about the order route.
When is the last entry?
21/4.
Then you get updated CD. Hard learning council for the party. This allegation against the petitioner. What is the name of the petitioner?
Remote Contractor.
He is not named here.
But my name is there, my lord. Not
Yes.
as accused fellows, but in the body fellows, my name is there. But the
Against whom certain allegations have been made along with other persons in respect of transport of pigs. How many pigs?
it is 165.
165 pigs. In how many vehicles? 3 vehicles, which were sought to be taken to Bondihat in Meghalaya from various places. Full stop. It was during Naka checking. What?
Yes, my lord. There is another meeting.
During Naka checking conducted by the police party, the animals were recovered. And an FIR accordingly was lodged, which is received and registered as Gosaigaon PS case number 176 of 2023. Learned counsel for the petitioner submits that he runs a dhaba in Shimolu Tapu. And the accused persons had named the involvement, had mentioned about the involvement of the petitioner. And accordingly, the petitioner apprehends that he be arrested in the connection with the same case. There are learned APP is available with the CD is available with the learned APP. However, this court feels that an updated CD is required to be called for. Accordingly, let the APP call for an updated CD. Meanwhile, if the petitioner is arrested, he shall be released upon furnishing a bail bond of rupees 30,000 with 1 local security like amount with the satisfaction of the arresting authority and subject to the following conditions. We shall appear before the IO within 7 days from today, and we shall not intimidate any person or influence any witness or temper any evidence, and he shall not move out of the jurisdiction of Gosaigaon. You are a resident there, Gosaigaon. Gosaigaon PS without written permission of the IU. Matter is to be listed again on 23rd of August for CD.
I think 72.
CD not received, BIO.
Yeah. Kind of page 16, the incident of 2030. The allegation is that 2 numbers of companies named in the FIR. They sold their share in the open market in the year 2019. I was told that one of the direct, there is no avertment made against me in any way.
I had learned counsel for the parties. This AP petition is filed by the petitioner praying for anticipatory bail. apprehending arrest in connection with which matter?
Actually, there is fixed on 11th.
Why is it come here?
Subsequently, order was stayed.
Uh-huh. Yes, 11,
Yeah, 6 on 11, subsequently order was made. And it was 6 or
There is no order here.
orderly.
Actually,
We go by the order sign.
Can you repeat something there?
Let it come on 11 because there's an order. We can't hear you. You have to come in front of the microphone. Yes.
That's why I made it before.
But the-
I made an action for.
This court has fixed it on 11. There is an order. So unless you have made a mention,
I made it
you made a mention before which court?
before, same court, but the court number 3.
No. All right. Then we can take it. Apprehending arrest in connection with so and so. I thought it was wrongly listed.
No,
Apprehending arrest in connection with so and so. What is that? The IEO case, ES case number 02 of 2000. Also, Learned counsel for the petitioner submits that he is what?
in the like electrician.
He is from Calcutta. Then who will assure his presence here?
Once he appeared, he received WT missions in the year 22. He appeared. Now on
He
20.
submitted that in respect of the investigations carried on. The petitioner, who is working as an electrician in a private limited company by the name Cranage India Private Limited, para number 1, page 3.
Yeah, the statement page 22.
Goes with that. The allegation in the FIR are in respect of purchase of preferential shares of certain companies. It is submitted by the learned counsel to the petitioner that he is a mere electrician and is no way involved with in respect of the financial transaction of Messrs. Win of Earth Marketing Limited. Although his name is reflected as a director. This court by earlier order dated 21/6/2023 had called for case diary. And the matter was fixed on 11/7/2023. Learned counsels for the petitioner submits that subsequently on 23/06/2023, matter was mentioned before the appropriate court, and the same was directed to be listed today, namely 4th July. And therefore, the matter is listed before this court. Where our learned APP submits the CD call for has not been received. He prays for further time. Therefore, let the CDB matter be posted, enabling the learned APP to call for the CD and place it before the court as directed. Meanwhile, if the petitioner is arrested in connection with so and so case, he shall be released on an interim bail upon furnishing a bail bond of rupees 30,000 with 2 local securities subject
My
to the
only one of the hearing there, my online complaint.
to the satisfaction of the arresting authority. And subject to the following conditions, you will appear before the IO within 10 days from today. And will not hamper or temper any evidence or influence any person. And shall not leave the jurisdiction of the concerned police station without written permission of the IO. matter be fixed again on 21st August. For CD. And about Mr. ABB has vehemently objected to the prayer for grant of bail or anticipatory bail as prayed for. And having heard learned counsel, this court is of the view. Yes.
For orders item 73,
Sorry,
So, he has to file an application to the.
I didn't hear you, sorry.
But the only difficulty then is that the petitioner is working in Kolkata.
Ah,
So, he has to stay in this institution.
we said you don't move out without written permission. That way better. Yes.
Yes, he was.
Why in I?
Three things happened. First of all, we don't respect several sections were applicable of the SPSC Act. But in fact, not applicable, that is made apparent, my lord. And in that, my lord, with all respect, my lord, some embargo is there. But that has been diluted, my lord, because the sections are not applicable, and PRS bill was granted. Now, my lord, in that application, wherein two were granted the privilege of PRS bill, two were not granted. And that is why there is a mistake that my lord, names did not tell you. That has been possibly, my lord, so that was only need correction. Second one, my lord, during pendency, we have to what police did, my lord, it is a fight between the police and the present petitioners or railway contractors, my lord. They added 307, saying that there is a threat to their life. And that is why, my lord, there is a mistake for extension of time, lord. These matters, my lord.
No, I don't understand. The originally the bail.
PRS bail.
Pre-arrest bail.
In the PRS
307 was not there.
no, they are.
So if it is not there, then.
Can I explain this?
Ah,
We are granted the privilege of PRS bail. Out of 5 petitioners,
hmm,
2 were granted because that their names were all right.
hmm.
And they are also, let me be very honest enough, my lord. When SPSC Act is attributed, my lord, there is an embargo regarding grant of PRS bail. If there is no specific case of SPSC Act, then it can be granted.
Hmm.
That has been clarified.
Hmm.
With all respect. Now, when 2 were granted the privilege of PRS bail, my lord, they have to appear within 10 days. When they intended to appear, what they did, my lord, stayed at 307. But that is a misnomer, my lord. Meanwhile, my lord, the bail application was moved. If that order is zipped, my lord, if I place it before your lordship, it will be, my lord, everything will be clear. No SPSC Act because the allegations are, my lord, putting some poison into some watery substance, my lord, that is not there.
This is preferred by whom? By the same persons.
No, well, these are PRS bail before your lordship. The person who sought bail, they have been granted by this order.
What do you want to show from this order?
My lord, with all respect, my lord. That is BA, my lord, with all respect, that is before 2233
Yes.
of the 23, my lord. There, my lord, lordship kindly will look at first page, second page, first paragraph, second paragraph, my lord.
Hmm.
Learned counsel for the petitioner also submits that those section 31 so and so of the Civil Custom Civil Rights Act that has been added to the case because of University Police, my lord, registered against the present petitioner. However, on cursory perusal of the same provision, it appears that the same provision of law is applicable only when one para or holds the water of any spring, reservoir, or any other source of water used by the members of the civil trust and civil tribe, which is not applicable in the present case. These are not the allegations, my lord. So SPSC Act is gone, my lord. Thereafter, we failed to appear within 10 days because the reason, my lord. This has been clarified here. Learned counsel for the petitioner also submits that the allegations against the present petitioners in the FIR is only that they threaten to kill, which does not justify invoking section.
Which does. Which does. Which does. Justify.
it has been granted, well, possibly that's some mistake, I'm sorry. That is, I mean, diary there is possibly nothing. Next slide, madam. Next last karega, madam. On the other hand, so and so. I'm sorry. But it is, no, it has been granted, madam, meaning thereby.
Anyway, we are not saying it has not been granted. We are only saying that the word is not does not, it says does.
That will also be.
Yes, then
Well, the diary was no material.
Simple, by side of shape.
no, but I am yet to understand why you have filed an IA. IA is filed for what purpose? What is your prayer in the IA? Modification of the order.
One of the PLS bail application, madam.
That 10 days.
No, that is one part, madam.
Then
The first application itself, madam, out of 5 petitioners, 2 were granted the privilege of PLS. 2 were granted, madam. 3 were not granted because of technical reasons. That is apparent in the order itself, madam. That is, madam, with all respect, madam.
So this IA is filed for, there is some correction you want to the name.
Exactly, madam. Exactly, madam. There is the order, madam. There is to be clear, madam. In AD 214423, order dated, madam, 16/6/23. Lossless found, madam. 16/6/23, madam. There out of 5 petitioners, madam, 2 were granted the privilege of pre-arrest bail, madam.
Yes.
Madam, first page, madam. After considering the submissions made by the learned counsel for the parties, as well as the amendments made in the petition, this court is of the view that till a final decision is taken and perusal of the case diary, the petitioners, namely Sukumar Devnath and Ranjit Devnath, be granted the interim protection till the next date fixed. These 2 were granted, my lord. However, the rest 3 were not granted because of these reasons, my lord. However, it appears from the petition that the names of petitioner numbers 3, 4 are not matched in the FIR. But this is the language, my lord, with all respect, my lord. As mentioned in the petition. Whatever names are there in the FIR in the petition did not tally, so these 2 were not granted. Therefore, the prayer for pre-arrest bail of petitioner number 3 and 4 be considered after perusal of the case diary. Regarding the petitioner number 5, his name was not mentioned in the FIR, therefore his prayer may be also considered after perusal of the case diary. So this is one, that was the IA at that point of time. It could not be taken up by
Yes,
petition,
yes.
come up for final hearing.
Yes.
Upon materials in the case diary.
Injury report is simple and background of the process, only the query in the state process. And other than that, the petitioners and.
But is there any finding by the court that this in the order which has been granted that scheduled caste and scheduled tribe is not applicable, that is not there?
Yes. I will read it. One of the section attributed is, my lord. Section attributed to the case. my
No,
lord.
no, I am referring to the interim, referring to the bail granted,
It is there,
16/6.
my lord. The
16/6.
order dated 36.
No, 16/6.
Right. In 16/6, it is not written. But have granted. You can place the judgments for me. Well, section attributed.
We can place the judgment, we can also consider it.
No, I have
But
asked.
it has to be on some other date.
Someone, it was not, I don't know. Well, now the question is, well, it all is second for the materials in the case diary. Section attributed is a section that is apparent on perusal of the order dated 36/23, the bail order. That is, my lord, well spoken, with all respect, my lord. There may just read one line, my lord, with all respect, my lord. On the other hand,
What is the allegation here
allegation I did
in the FIR?
cross cases, my lord.
I think this will require some amount of hearing.
Well, if you take 1 minute, but it's only
1 minute for you.
Well, page 17, madam.
Yes.
Page 17, madam.
Ah.
Page 17, madam. I beg to inform today that so and so, below noted accused persons came in 2 vehicles, bearing number so and so, so and so, so and so. It goes on, my lord. There were physical assault and there are 2 lines, my lord. Regarding SCFTA, I'm frantic, my lord. My family member said SCM lower caste and intimidated my son that they will shoot him and other family members to death at any time and hence created panic in my family. My son is now under medical treatment. These are all available offenses, my lord. 325. No 3. The accused persons are very dangerous, goes on and on, my lord. This is one affair. On the same subject matter, there is a cross affair. That is at page, my lord, with all respect, my lord. 22nd. 27, my lord. Same occurrence. Page 27.
Now you are against the FIR at page 17.
No, page 17 is against us, my lord.
That's right, against which you have filed this bail application.
Absolutely, my lord. The FIR will only at page 27. Now, one of the diaries.
So where is the allegation of 3110?
3110, my lord.
Where does one find it?
3110
It is registered under 3110.
3110, my lord.
Schedule cast.
My lord.
No, we're trying to go through the act.
Oh, look, again, I'm missing it. It is not there. I'm reading it, my lord. The offense certificate. My lord, 310, my lord, I'm reading it out, my lord, we call it. Corrupts or pulls the water of any spring, reservoir, or any other source.
Yes,
That is at page 10.
yes,
X was 10 was.
yes.
Corrupts or pulls the water of any spring, reservoir, or any other source ordinarily used by members of the civil class or civil tribe, so as to render it less fit for which it or it is ordinarily used. No allegation says such. No such allegation. That occurs in case 10, it's the same. 310. Another section is 310. X.
What is the allegation here in the FIR?
Saying that
Physical assaults.
assaults, those are available.
Physical assaults.
Assaults. To bring it within the ambit of 310, my lord. Corrupts or fools, nothing has found you. Nothing has found you.
Yes.
Corrupts or fools, the water of any spring, reservoir, or any source ordinarily used by members of the civil caste or civil tribes, so as to render it less fit for the purpose for which it is ordinarily used. My lord, absolutely not there.
That is all right, but whether it is sufficient to come to a finding that the provisions are not applicable, because it could be a wrong quotation of the section.
Well, no, that is not. It is that. This is one paragraph. It has to be specifically in the context of civil tribe and civil caste. If there are other disputes.
No. What I'm saying is, supposing if you go to 3A, 3B,
Yeah.
sorry, 3C.
It is. That
There it is, my lord, apex code is clarified, my lord. If it is within, not within public view, my lord, sections cannot be affected, and it has to be specifically in the context of scheduled tribe and scheduled caste, my lord. That
Correct.
paragraph I am reading now,
Correct.
my lord.
What I'm saying is, if supposing there is a wrong quotation of the section,
Yes.
some other provision ought to have been applied.
So some other provisions may come into play, my lord.
Yes,
If you-
then your 438 is barred. Specifically 3.1 X is not applicable, we agree.
Right.
But to say that
I had placed my lord 2 affairs before the lordship, and what the apex code has.
Yes.
I'm reading it.
what is there in your CD, sorry, what is there in your CD?
Yes, lordship. The information of the victim boy, lordship. Here is analyzed by professional. Here, petitioners and the victim boy. It is well-known relationship by each other, lordship. If defective is the side of the construction site, then one day small confrontation took place. That the subject started there. I have always the inquiry report, lordship, simple and by term. Around the concerning the SCS provision sector. No, I am not formulating the provision sector.
My lord, regarding your lordship's query, my lord, that ST Act applicability, my lord, may I just reading it and placing it before your lordship. As held by the Supreme Court, the offence must be such as to affect the offence of the so-and-so section. The offence must have been committed against the person on the ground that such person is a member of civil caste and scheduled caste. In the present case, the fact that this requires that for a 302 case was belonging to Pungal scheduled caste is not disputed. There is no evidence to show that the offence was committed only on the ground that the victim was a member of the scheduled caste, and therefore have I made my question clear, my lord? Because there are other disputes, my lord. No dispute, my lord, 438 will fly. Well, it can be done in this manner, my lord, with all respect to you.
yes,
It can be with all respect, my lord. So far as the petitioner concerned, my lord, 2 were granted, 3 were not granted because of some technical. Have I made my question clear, my lord?
no, but the reason for not granting or reason for granting is again not on the ground that these clauses don't apply.
That was not exalted.
No, we are only trying to see if assault or physical injury is also one of the grounds inflicted upon a member of the community is also defined as a specifically defined for punishment.
Yes, it is there, my lord.
Where?
It is there, so. It is there. My lord, R, my lord, R.
No, with the intent to humiliate,
Yes,
that is on a different issue.
yes.
But what I'm saying is, supposing, as in this case, there was a physical assault, abuse, somebody got hurt, and that person happens to be a member of the community.
Fine.
Does it include a?
What the apex court has said in so many words, my lord, it has to be specifically in the context of being a member of the scheduled caste or scheduled tribe community. Not otherwise. If there is a land dispute, it will not do. That authority of the apex court is clear. Then, my lord, the embargo of ban on 438.
If a heard counsels for the parties, this anticipatory bail petition has been filed by the petitioner. Which petitioners? 3 and 4.
My lord, 3, 4, and
Has been filed by the petitioners 1, 2, 3, 4, 5.
my lord. That's all.
Apprehending arrest in connection with Bongaigaon PS case number 231 of 2023 under section 12. of this court by earlier order dated 16/6/2023 had granted anticipatory bail to
One and two.
the petitioners 1 and 2. The bail in respect of petitioners 3, 4, and 5 was not considered as their names
Did not match.
did not match with the names reflected in the FIR.
Right.
However, their prayer for bail was not rejected. Learned APP has produced the CD. The CD reflects that injuries caused have been stated to be minor. And there is the petitioners and the person injured are known to each other from some time past. On the date of the occurrence, in view of certain disagreements which followed between the petitioners and the person injured, and altercation took place, and accordingly, because of the commotion which arose, certain the accused the persons who are the persons informants? Who is the informant? The informant's son sustained certain injuries slash bruises. Full stop. Learned APP submits that the injuries are simple in nature and no previous injuries are noticed. The investigation is progress. Having heard the learned counsel for the parties and upon the result of the pleadings on record as well as the CD, this court is of the view that the FIR was received and registered as Cohabitation PS case number so and so under section so and so, read with section 3(1) within NREGA Acts of the Civil Class and Civil Tribes Act 1989. Also, provision of the Act of 1989 reveals that scheduled castes that section 3(1)(x) relates to offenses 3(1)(x) reads as under. Extract 3(1)(x) from the FIR as well as the submissions of the learned counsels for the parties read with the pleadings as well as the CD. No materials are seen to attract the provisions of section 3(1)(x) of the scheduled castes.
Right.
There is no allegation that any act or omission was committed by the petitioners which will attract the provisions of section so and so. Having said that, this court is of the view that the bar under section so and so,
Section 18,
section 18, will not be applicable in the facts of this case, and therefore the matter is taken up for hearing and disclosure. Upon hearing the learned counsels for the parties and upon consideration of the pleadings on report as well as the materials available in the CD. This court is of the view, and also taking into account the order passed by the coordinate bench dated 16/6/2023, passed in AB 2144 of 2023. What is that other order connected to the same issue? Same arising out of the same order, same FIR, bail application, as well as the order dated
36/23. 6/23 in BA 2233/2023.
36/2023 in BA number
2233/2023.
2233/2023. This court is of the view that the prayer for anticipatory bail can be granted. So, the
Basement. We get here.
In the IA, what have you stated? What, which is the correct name?
We have accepted the correct name.
Huh?
Both the names we have corrected. Now that is not necessary because Gossip has received the CD. That will be made not this way.
All right. Upon due consideration of the materials, this court is of the view that the prayer for anticipatory bail in respect of petitioners 3, 4, and 5 can be granted. Subject to the following conditions. The petitioner shall be the prayer for anticipatory bail can be granted. In the event the petitioners are arrested, they shall be released on furnishing a bail bond of rupees 10,000 with a suitable surety, solvent surety of like amounts. The the bail, anticipatory bail granted shall be subject to the following conditions, which will appear within 10 days before the IU, and other conditions. Now, which is to be not pressed? There are
What may be not pressed.
what in view of the order passed. This is being taken IA 560 and IA 532. In both these, you say in view of the order passed today in AV petition 2144, IAs are not pressed in this case. Yes,
Production is item number 1.
yes, Mr. Tara.
Gracious,
No, no, no. Item number 1.
Yes,
by means of this application under section 482 of all of legal procedure, the petitioner is challenging the legality and validity of the charge sheet number 19 of 2020. So
tell us the facts of the matter. What?
yes. Let us go through the composing chart sheet. We come at page 53.
50.
50.
Yes.
The brief fact of the case is that on 03/11/2020, based on findings of an inquiry, the inquiry officer MS so additional SP Bureau Investigation Economic Office has lodged an FIR stating the directors of Response Real Estate and Construction Private Limited had previously conspired and indulged in keeping and misappropriation of public funds under false promise of good profit under various fraudulent schemes by opening branch offices in the different districts of the town. The inquiry had revealed that the directors partner of the Response Real Estate and Construction Private Limited had engaged in illegal collection and swindle use amount of public money during the period of 2009, 10, 12, 14.
Further, they had misguided and encouraged many innocent people to invest their hard and money into their fraudulent schemes and later fade away after closing their branch office and the case.
Now what has happened after the charge sheet?
Now, just one more paragraph I want to read. During the investigation, examining the complainant and as many other witnesses received that their statement under 161 CRPC. From their statement, it is learned that the accused person named is so and so Mallory Martha, so and so, these are the directors. Basically, the FIR and the allegations are against the directors of the company.
What is the name of the company?
Yes, name of the company. The fifth, last time I'm reading. At Guwahati, Sibsagar, Dibrugarh, Johor, Lanka, Gohapur, the Tipu, Demazi, and collected money by company through their agent. The company responds to the LPSO and so I will break. Now, I mark the word to the agent in the line 5. These agents have not been charge sheeted. And kindly come to page 51 for one more purpose. The only allegation against me. Page 51, 1, 2, 3, 4, 5, para 6. During the course of investigation of the case, it is found that managing director Sri Jyotish Gogoi, along with associate directors Sri Vikas Gogoi and the Rajani Gogoi, director, Sri Rukmani Bora, director, Sri so and so, coordinator, and I am here, Sri Chandan Bora, branch development manager of the respondent company. Came into a conspiracy and closed on Guwahati-based head office and other branch office of the company in the month of February 2014 and later. So, kindly mark this particular sentence. The only criminality that I have committed is closing down the office. Now, I make a reverse submission, invoking the doctrine of the master and servant relationship. Now, the directors are the owner of the company. I am a mere branch development manager as an employee. Not even I am a delegate agent as defined under section 10 of the Consumer Act.
Where is your appointment order?
Well, I'm coming to that.
Yes.
So, moment the master stopped paying the rent of the house, and the electricity bill and the recurring expenditure, as a mere employee who is drawing 6,000 rupees per month, cannot afford to pay the money. So therefore, the criminal breach of trust has projected under section 406, the entrustment of property is an essential ingredient to attract section 406 of the Indian people. Now, kindly come to my regulation that connected to page 18. Page 18, 1-8, connected to
Yes.
so and so managing director, 31/7/2018. Something regulation. Sir, I agree to inform you that from 1st August 2018, I will no longer be working as branch development manager at your company, Response Real Estate and Construction Private Limited. Please consider this my official resignation letter. Although the experiences at Response Real Estate and Construction Private Limited has been wonderful for me, I have decided to move on and further my career elsewhere. I would like to express my gratitude for providing me the opportunity to work in your company, and I wish you and Response Real Estate and Construction Private Limited continued success in the future. Now, let me frame the question of law. After reading this, the question of law is
There is no question of law. You are before a court in the criminal petition, sitting for quashing.
yes, that's right.
So where is the question of law? You decide on, first tell us the facts.
Legal fiction is coming up in this case.
No legal fiction.
This is a case of multiple FIR. This is a case of multiple FIR.
Those will see, but now you tell us what is your prayer here today?
Yes, my prayer is for staying.
Stay of what?
In respect of the church 19.
Why?
Against me.
What is the stage? What is the stage now?
The stage is appearance.
Then
No,
you appear.
no,
Unless you appear,
no. Can we try to recall, allow me to place under Ranjan Goswami's judgment. The apex court has dealt with, under Ranjan Goswami's case, there was a multiple FIR in all places on the same set of facts and same course of action. In that even the law is very clear. Paragraph 13.1 of the Arnab Goswami judgment.
where are the FIRs?
FIR, we have read in the complete that's it.
Huh?
Is a
No,
complete-
you say multiple FIRs.
Yeah. Page 28, my brother says.
Page
28.
28.
I come. What happened is the director's law, or the director, who are accusing another case, has already been granted the bail by this honorable court. Now, the question comes, the larger question remains, can there be a separate trial and separate, can there be a separate FIR and separate trial for same course of action, same set of facts and.
Where are the multiple FIRs as far as you are concerned?
It is reflected in the bail order.
The bail orders are relating to those persons.
Yeah, those persons.
So why they are not before the court, you are before the court.
No, they were already before the court and they were granted bail.
No, what I'm saying is your case is that there is a charge sheet where you are named as an accused.
Correct.
And it is your case that there are multiple FIRs filed, yet the court has taken cognizance. That is your short case.
Yeah, but there are two things.
Ah.
There are two things. For there is another transitor. One second. There were.
We'll issue notice at this stage. You will fix it on the reopening day. You come back and urge the matter. When is the next date fixed? When is the date for appearance?
Yeah, 30.
30.
13.
13.
Yeah.
All right, heard learned counsel for the
But
petition.
protect us,
This criminal petition. Yes.
Something I would like to know, they are found with the intent that charge sheet of November 2020. And after the NBW order or NBW order passed on the 30th of January 23, that NBW order is not annexed in the petition manual.
Some NBW has been passed.
Yes, they have mentioned in case 13 paragraph.
You get a copy of their NBW.
There is not annexed. On 30th of January.
You are praying for suspension of the NBW. Go and appear. We'll set aside this NBWA.
Correct.
We'll not set aside. We will direct you to appear on the next date. If you appear, we'll direct the NBWA to be recalled.
Recall.
And you make your regular prayer before the court.
So gracious, Lord.
Will that suffice your
That is the purpose. I'm gonna leave the.
okay requirements? Okay, hard learned counsel for the petition. This criminal petition is filed for the petition praying for setting aside the charge sheet filed by the IU in connection with BIEOES case number 19 of 2020 under section so and so, read with section so and so. Also, the matter is presently pending before the court of SDJM1 Kamrup Metro as PRC case number 3097 of 2022. It is further submitted that the petitioner who was working as a branch development manager of the what company?
The real estate.
Of the real estate company had tendered his resignation as per Baker's 31/7/2013 as is reflected in page 18 annexure 2 post of learned counsel for the petitioner submits that notwithstanding his resignation from the company, the IO has filed the charge sheet whereby he is also shown as one of the accused persons.
Accused person.
Full stop. Being agreed, the present. That apart, the competent court before whom the matter is pending has issued an NBWA dated 3001/2023 against the petitioner, as the petitioner failed to appear before the competent court. Mr. Courtroom, Learned APP submits that the matter is fixed on matter is at the stage of appearance, and the petitioner be directed to appear before the competent court. Having heard learned counsels for the parties, this court was of the view that the petition can be disposed of with a liberty granted to the petitioner to appear before the competent court on the next date fix, which is 13/2023, and thereafter file necessary applications, if so advised, before the competent court. Full stop. If the petitioner appears before the court of SDJM1 Kamrup Metro on the next date fix as directed, then the NBWA issued on 3001/2023 shall be recalled. Full stop. Till 13/07/2023, the NBWA 01/2023 shall not be enforced. Full stop. Upon the petitioner appearing before the competent court and filing in necessary applications as advised, as may be advised, the competent court will decide the said application on its individual merit, on its own merit, taking note of the judgments rendered by the apex court laid down in Siddharth versus Wenzo and other judgments.
That is should be kept alive because
These judgments are available before Poliga and get out Siddharth and 3 other judgments. Yes, the competent court will pass appropriate orders, taking note of the law laid down by the apex court in so and so.
let this petition be kept alive. We are raising the quorum of the court because that's under the repeal act. If we strictly interpret section
You are
6
praying for two things, you can't do that. If you are washing, if you are challenging the washing, then
Wait, only, Madam, can you make one observation?
since this petition has been disposed of
With the
only on the
negotiation,
limited issue
yes,
by interfering, by directing the petitioner to appear before the competent court, liberty is granted to approach this court again if any. Why do you want liberty? If you're not questioning it, not necessarily.
always has to be taken.
Liberty is granted to the petitioner to approach this court to for now what issues we want to raise?
Can I take the jurisdiction of the landed court below? Because you know, 2023, you know, that the Assam protection of interest of the positives in financial establishment repealing adequacy of the queue has been repealed, you know. So now under that provision, these provisions have been taken. Now, you know, if, in terms of this repeal, section 9, if you not see, then with prior to the repeal, then the section 9 completely bars the sub judicial administrative.
Since the petition is disposed of on the limited question of on the limited issue of the NBWA issue against the petitioner, Any further issues which the petitioner seeks to address the court at a relevant point of time would remain available to the petition.
Grateful.
Criminal petition, both of these stand dismissed. Sorry, disposed of.
Item 2.
Yes. Yes,
Madam, petitioner have in peaceful manner. They belong to my present us completely. And whether
there is some eviction of fraud. There is some eviction
yes,
from where?
whether the
Government land.
Government land.
government land budget, but they are, policy based 56. Government land, they have been residing for the state plot of land bylaw since 1954.
Have you filed any applications with
Yes,
you?
several times to find bylaw.
Yes, Mr. Sharma,
Yes, bylaw.
what to do?
My learned friend has stated that they are residing there from 1986, but their genuinity lordship, for some doubt in my mind, lordship, because lordship kindly come to page 40. This is the application they had made. Page 40.
You examine the matter,
Yes, but because lordship, no, lordship.
If they are available on this land for that many number of years. And
May I? They have stated that there is an issue number. They have manufactured this document that I want to show that they have not come with clean hands.
what is the issue number?
Inside 41, 5/1, 1986,
Page number
40,
40. 41.
40.
I know. What is the number you want to tell?
According to them, in the left hand side, it's 41, 5/1, 1986, which is put by the department. Now your lordship kindly comes to page 52.
52.
The same application. Where is the issue number? So according to, apparently lordship, it's a manufactured document. And lordship, they have already approved the civil code.
What is the order date?
In the civil court, lordship, their application has been dismissed. Thereafter, they did not appear in the title suit. In the miscellaneous application, that title suit was dismissed. And accordingly, thereafter, they did not appear in the title suit. Accordingly, that was also dismissed for default. Their lordship again approved this honorable high court. That order, they have that application they have withdrawn, and we have received that parawise comment in that application. And the case which is pending, another case lordship which is pending before this honorable court, that is the order lordship. They have been directed to produce the land, that whether they are cultivating, they are not, by showing some photograph.
Yes, my that is there, madam, but we can the for heavy rain, my
They can
underwater.
They can annex those documents.
Have you
They are-
made the statement that you have approached this court
Yes.
before title suit,
Yes.
etc.?
No. They have not mentioned anything regarding the title suit.
That is not my lord, the.
And regarding, what is the answer
My lord, the.
regarding this page 40 and page
At the
51?
time of issuance of this notice, the revision notice, my lord, no.
Otherwise, I will not have got it. Regarding eviction matter, I will not have.
No opportunity of hearing.
Have you gone through the land revenue regulation ever? There is a set of regulations.
Yes,
Have you gone through that?
yes.
There is a specific provision that if you are illegally occupying government land, no notice is required.
Schedule cast. Remember, my lord.
Maybe, but it is a government land. What have you done?
And your lordship kindly come to the notice, where is the wrong in the notice?
Notice, my lord.
If you have approached the title suit, civil court, it has been dismissed. Where have you stated all that?
No,
I have no instruction, yes.
You have no instructions, then you get your instructions on this and tell us.
Yes, my lord, I get instruction. Nothing else.
List again on 17. Enabling the learned counsel for the petitioner
After 20.
to obtain instructions as to whether the petitioners had approached the civil court in respect of the same issue. by
regarding the same plot of land.
regarding the same plot of land by title suit number
Title suit number 13/2016.
13/2016. And which was stated to have been dismissed. As well as,
Say case number also 13/2016.
as well as the further appeal.
No,
No appeal.
That is for interlocutory order.
Okay. Along with the Miss J case number 13/2016. Also. Let this information be placed before the court on the next.
After 20,
Give us a date
20.
on the next date fixed.
Let the matter.
These submissions are made by the learned government advocate, Mr. H. Sharma. Opposing to the prayers made in the writ petition.
Let this matter come along with that WBC.
It is further submitted that there is another writ petition pending before this court, being WPC number 3076
of the
2023. The matter is accordingly, let this writ petition, both the writ petitions be listed together on 20. I do not know what is the next date for this matter.
No, okay, it was fixed, but.
Fixed on 9/6.
Yes, I think.
Left over.
Till then, somebody.
No till then. No.
The person said, that they are traveling across the.
First, you get the information whether you would approach the court below or not. You get this information, you tell us that his submissions are incorrect.
Yes, man. Till then I.
What till then? What till then, if you are not instructed properly by your client? Where is the question of giving the
Lordship seeks 1 acre of land.
My lord, kindly consider
Is it possible?
all partners of their for a father and their mother, old aging mother, my lord. They have children and wife, their wife. My lord.
these do not give you.
So, the meantime, my lord.
No, you first tell us, you come clean before us, before you, therefore, if you are evicted, we'll put you back in place if you tell us that this information is incorrect.
No procedure. Kindly, my lord. Otherwise, we will keep in midnight.
List on 20.
Though there is no such conflict, but we have instructions that he is occupying the land and sell it to some other person. So there he is doing that. That is what instructions tell him, but even then not, I am not.
We'll list on 20. That's all we can do because you have to come with proper information. You have no instruction, that is not your fault, but your client can't be given the benefit. You can't be helped unless we are certain that you come up with clean hands, we cannot give you. We can set it right if you come back with the proper instructions. All right.
What's okay?
How many parents? 6, 7. Production is one. कितना गया है? एक production is one हमारी बात. Oh, file तो publish है, file तो भीतर है. अपना judgment is है. File तो कैसे करेंगे ना?